may I speak, Lord?
Yes.
I beg to mention item number 50, your Lordship. It will be PL number 50, but I have a PF question at medical matter. I have to get 2
Item number
50.
50.
50. Can it be taken on Friday, my Lord? No doubt this is very important regarding retirement benefit. They have filed the affidavit and assured to be released 50%. Likewise, for a similar person.
Mr. Sharma, getting the matter listed is a difficult thing. You want an adjournment, I can give you.
Today is actually morning fasting sugar is already tested. I was called upon at 2 p.m. my Lord. That is the only problem.
Understood, but then also to accommodate. There is no problem in accommodating you, but I can't give you on Friday. Sorry.
Next Monday, my Lord?
No, you come over to 4 weeks.
Lordship, kindly 2.
No, sorry. At the request of Mr. B. Sharma, matters can be adjourned for 4 weeks.
Particular date may be mentioned, my Lord, very difficult to get it. So.
That is why getting a matter listed and then going out.
It was not fixed today, my Lord, but
therefore it will not be fixed again after 4 weeks.
Let it be. I shall cancel my medical appointment. I shall remain here, my Lord.
No, that is your lookout. I am not saying that. But I am not going to.
No problem.
Yes.
Please, Lord. Probably I mention item number 48 of today list. Item number 48.
48, yes.
Actually, my Lord, in this case, my Lord, I'm for respondent number 8 on behalf of each secretary, my Lord.
It is each check, my Lord, at 2 p.m. today.
His wife is hospitalized, my Lord, and he is busy there, my Lord. So I'm saying that maybe after 2 weeks.
Already hearing is over.
We have taken the function of the other.
Which matter is this?
It's a review matter, my Lord.
Obviously, it looks like a review, but why? What is that matter? Oh, that matter.
That's, my Lord, date of birth. I'm senior, he is junior.
My Lord, actually, the engaged counsel wife is hospitalized, and he is busy there, my Lord. It could not come 2 weeks, my Lord.
Who is hospitalized?
Wife of advocate female secretary. Wife of advocate female secretary. I'm saying to up to this matter maybe after 2 weeks, my Lord.
We'll have it after 4 weeks.
My Lord,
Can't help it. Listed at the
that is
request,
after 2 weeks, my Lord.
at the request of Mr. Huh? So and so appearing on behalf of the respondent, matters can be adjourned for 4 weeks.
Your Lordship, in item number 56, in order to follow, I may be allowed to do some correction by hand because while going through the application, I found it, the annexures were marked wrongly in the IDA.
Item number?
56.
Okay.
Order.
Please, Your Lordship. In connection with item number 60, I have filed an additional affidavit. Please allow me to take it. Item number 55 of today's report. But a similar matter is coming up on 29th of May, Lord. The matter relating to not payment of retirement benefit and area salary, Lord. Assam Plain Card Development Corporation.
Those. Okay. You have the matter.
29th.
Item number 55 list on so and so on 29/5/2023 along with WPC number
5636 of 2016.
16.
Listing Lord, pension matter Lord. Leftover Lord 3/5/2023 Lord.
Huh?
3/5/2023 matter has been leftover Lord. Pension matter Lord.
All are pension matters. Then give me a good reason why.
Better pension matter.
All are pension matters. Why should I give you any special? Why should I give you anything for that? Give me a good reason. Why? All the 60 matters out here are pension matters. Then think about it. Again, mention on Wednesday. Next.
Your Lordship, in this writ petition, the sanction letter has already been issued on November 2022, but till now they have not released the money. That's why I
Sanction for what?
leave encashment 300 days.
Till now, you have not got it.
From November only till now they have not taken. Just the same.
Bring it by way of an affidavit, additional affidavit, then mention. Next.
Lordship, item number 26, Lordship, with the consent of other side. Lordship, this matter may be adjourned for a week. We will be filing an additional affidavit in this case, my lord.
Item number 26.
26, my lord.
At the request of the Mr. R. Karim,
R. Karim, my lord.
matter stands adjourned for 4 weeks.
Lordship, another matter, Lordship, item number 45.
Yes.
It may be adjourned, my lord. Lordship, 1 week.
You are, yes, at the request of Ms. Why?
Lordship, certain instruction I am to.
No. It's a 2015 matter. Why the matter has come up for orders? You know? Find it out, then
Lordship.
we'll
Lordship.
look into it.
It is item number 8 of today's my lord. I
Yes.
have deposited my lord deficit court fee today, my lord. It is
Huh?
not deficit court fee, my lord, today, my lord. It is not in the record, my lord. May I pay that matter? Maybe make it taken up in some other day, lordship. I have already
Item
paid
number,
8, lordship.
yes, what is the problem?
My lord, I expected to deposit deficit court fee, lordship.
Yes, you have not done
I
it.
have deposited today, lordship. And due to my mistake on my part, it was not deposited earlier, lordship. So may be taken up in some other day, lordship. I
You have
already
deposited?
I
No.
already deposited, lordship.
Okay, then
Today,
what is the problem?
my lord, this is not recorded in the
Not required. You have
Okay.
deposited, we trust you.
obligation.
Yes, no problem.
May please, Your Lordship. Lordship, I beg to mention item number 3 of the release.
Item number?
3, Lordship.
Yes, why?
Lordship, in this engaged company, Mr. Ayal is hopeless today, Lordship.
What is the matter about?
I am not in this case.
Don't mention it. We'll see.
Mr.
Then
Ayal is
next,
May I please, Your Lordship. Item number 31, Lordship. This matter may be taken up at 2 p.m. Lordship.
why?
Because Lordship, the issue which they have raised, Lordship, that has already been decided by this honorable court in a matter, Lordship.
Which matter?
Sanjita Roy case, Lordship.
This matter pertains to the Sanjita Roy.
Similarly, Lordship. That's why if Lordship has taken
6
up,
years.
Lordship, at 2 p.m. Lordship,
Chalo, we'll try.
deeply obeyed.
I beg to mention for listing a matter. The matter pension to that the matter pertaining to pension, the petitioner person has not been finalized
Mr.
yet.
Counsel, you mentioned it last Friday. Okay, now tell me what is the reason why you are mentioning again?
The petitioner person has not been finalized yet. He is old person.
What is his age?
A Hussain.
Not the age.
A Hussain
Age,
is my
not yours.
68. 68.
68.
Yeah.
And when did he retire?
Hello?
When did he retire?
2022.
And now he's 68. What type of job it was that? 68 and now he retired in the year 2022. Sam, I think the age of retirement is 60.
Sorry,
Then,
my lord.
okay, again, try your luck on Wednesday. Yes.
Item number 1 for postpone.
Wait to battery setting like here, is it? Good, lagi. Yes. Tell me, what is your case about?
My lord, this is a matter, my lord, wherein we are praying for, my lord, payment of our arrears and my lord, from the year, my lord, 1/1/2005 to 22/12/2004, my lord.
Hmm.
This is a matter which was initially dismissed by the Honorable Single Bench, my lord. Then, my lord, the Honorable Division Bench, my lord, was pleased to remand back this matter for consideration on merits, my lord. But the common substance of this matter is, my lord, that the petitioners were initially serving as, my lord, honorary teachers, my lord, in respective schools of, my lord, Kokrajhar and Tirang district, my lord. Now, what happened, my lord? There was a writ petition, my lord, WPC number 7123/2002. Lordship will find that on page number.
So your writ petition was dismissed earlier on the ground of
My lord, yes, my lord. It was dismissed on the ground that.
the period of 3 years was much
Yes,
over.
Yes. But
Now
then
the division bench have remanded it back,
remanded it back, my lord.
saying
Saying, my lord, that to decide this matter on
merits.
de novo on accordance with law.
Now, what is your case?
So my case is that, my lord, initially, my lord, I was appointed, we were serving since, my lord, 1986, 1987 as honorary teachers, my lord. There are 70 of us, my lord. Now, what happened, my lord? I would like to take your lordship to, my lord,
Have you paid the court fee?
My lord.
Have you paid the court fee?
Okay.
I give you two options.
My lord.
Either choose one petitioner of your liking for whom the order has to be made, or pay the court fee. Isn't it everybody's case that they are entitled to area salary?
Yes, lord. Okay.
Then why the court fee of only one person has been paid? Why 60 rupees has been paid? You have 60 petitioners, 70 petitioners, not even 1 rupee each.
My lord. I was under the impression that they have a common grievance, all of them.
Fantastic. So then let one person get his salary, then it will be common for everybody. Would it be enough? Then
I apologize, my lord. May I pray, my lord, will take it up at 2, perhaps, my lord, I will take it up at 2.
don't worry. We'll issue notice by you pay your court fee.
My lord.
Heard, mister?
You Pathak, my lord.
You were working as?
We were working as now as assistant teachers, my lord, in lower primary school in Kokrajhar, my lord.
No, you are asking for, you were regularized on 1/1/2005.
Yes, my lord. But the problem is that, my lord, back then, my lord, when the regularization was made, my lord, it was made against non-available post. We were given regularization against sanctioned post only with from 23/12/2014, my lord.
Prior to that?
Lord?
Prior to that?
Prior to that, my lord, we have been regularly discharging our duties, my lord.
Show me your regularization order.
The regularization order of 1/1/2005, my lord, that order we do not have because, but we
You
have
don't have that order.
but we have the memo number, my lord.
No. Show me you have to show something, some document you have to show
And
that
my lord,
you have been.
And my lord, if I may submit, my lord, one small submission, my lord, we also
No,
requested
show me which order by which you are claiming regularization. Show me.
my lord.
Mr. Counsel, this will save you a lot of court fee. Yes, Mr. Khatunian.
I could find the regulation order, my lord. I have find some retention order, but regulation order is not there, my lord.
Show me the 2014 regularization order. You are not ready?
My lord will take it up at after some time, my lord.
No, not after some time. You have to be ready. We'll have it on next week. Okay?
My lord.
What is today? Today is 15th. We'll have it on 22nd. Pay the court fee in the meantime.
My lord.
And prepare yourself. Heard, mister?
You Pathak. You Pathak.
You Pathak, the learned counsel appearing on behalf of the petitioner. It appears from the records that the petitioners herein, who are 70 in number, are claiming their individual right to receive their salary for the period from
1/1/2005.
1/1/2005 to 22/12/2014. Full stop. During the course of hearing, no, full stop. In that view of the matter, the rights of each of the petitioners are separate and distinct from each other. It, however, appears from the records that the court fee of rupees 60 has been paid, that is for one petitioner. The learned counsel for the petitioner submits that he would take necessary steps for payment of the deficit court fee if some time is granted. This court also, during the course of the hearing, asked the counsel appearing on behalf of the petitioner as to on what basis the petitioners are claiming salary from 1/1/2005. To stop. No document, however, has been, the learned counsel, however, have not been able to show any document. Let the matter again be listed on 15th of May 22nd of May 2023. By the said date, the learned counsel, the petitioner shall pay the deficit court fee. And the learned counsel shall also point out on what basis the petitioners are claiming salary from 1/1/2005. Petitioner is further given the liberty to file an additional affidavit if deemed fit.
Item number 2.
This matter was backed up again, released from this. It is by my this matter was backed up with others matter, then released. That is by in motion column listed. The prisoners was by selection appointed as assistant teacher of LP school, Dhemaji district, my lord. And then he crossed the confirmation, the cross efficiency part. But 2008, my lord, the salary has been suddenly stopped, and he approached for the first time in this honorable court. This honorable court has passed some orders, my lord. After that, the salary has not been released. And the whole crux of the matter is this, my lord, page 36, my lord, this communication. It says that some irregular or illegal appointees also.
Show me your appointment order.
My lord, appointment order is, my lord, page 18. After selection notice.
Who has given?
My lord, it is given by DI, my lord.
How do you know?
My lord.
Why is it in the translated copy nothing mentioned?
Yes, my lord. In Assamese copy, it is page 20, my lord. Dhemaji. It is at 19/12/89.
Then what happened?
Then, my lord, an XRC joining, he joined against the vacant post, sanctioned vacant post, my lord.
Yes, Mr. Khatunia. As regards, who is there?
My lord.
You are secondary education
Yes.
or primary elementary?
Elementary.
You are elementary.
Yes.
You are elementary education.
Yes.
Now tell me why his case has not been considered in respect to those people who have been considered in the on 7/10/2020. The government's decision of 7/10/2020. Why the petitioner's case has not been considered?
My lord,
Are you aware of what has happened? Okay, where is the counsel who normally appears out there, who knows about these facts? You are not aware.
Yes.
Where is Mr. P.N. Sharma? Where is Mr. N.J. Khatunia? They know all these facts.
Going to
We'll take up after some time when the people who know come.
Item number 3.
None appears on behalf of the petitioner on call. Mr. A. Chakravarti appears on behalf of the state of Assam. It appears that on 12/4/2023 also the none has appeared on behalf of the petitioner. And this court had made it categorically clear that if the petitioner is not represented on the next date, the petition will be dismissed for non-prosecution. Taking into account that none has appeared today also matters, the writ petition stands dismissed for non-prosecution.
And now 4.
Please, your lordship. Lordship, in this case, I am praying for a scale of deputy commissioner while holding in charge deputy commissioner, lordship. Actually, what happened, lordship?
You are
Earlier-
praying for?
Scale of deputy commissioner while holding the in charge deputy commissioner, lordship. Actually, what happens?
How is it possible?
Lordship, similarly situated persons were given a scale, lordship.
Madam, kindly don't go into what the illegalities the government does. I'm not on that. You are to show me that a person who is given the in charge is also entitled to the scale. Show me a document for that.
Lordship, kindly come to page number 28, lordship. Paragraph 2, second paragraph, lordship.
Yes.
Sri Khaninder Talukdar claims scale of pay deputy commissioner with effect on so and so. Disposed as per view of the financial. He is entitled, therefore his claim was considered in the meeting approval the proposal. And paragraph number 3, in view of the petitioner would be entitled to the scale of deputy commissioner with effect from so and so while he was holding in charge deputy commissioner at disposal. Second letter, page number 29, lordship.
No, on the last occasion, if I remember, when
Yes,
the matter
lordship, I have
came up,
already filed.
this matter had come up, then I put the same question. Then
Yes,
you
lordship.
said that there is some office memorandum to
Yes,
that
lordship,
effect.
I have filed the affidavit in the
Yes, what does it
additional
say?
affidavit, lordship. Yes, lordship.
Show me that document.
Yes, lordship. 46, page number 46 of the additional affidavit, lordship.
46.
Yes, lordship. Now, lordship, they have after filing of this petition, lordship, on 11th of
Where? Page number 46, which one?
yes, lordship. Serial number 8 and 9, lordship. 9, lordship.
8 is
Nine,
nothing,
lordship.
9.
Yes,
As
lordship.
the subject
As-
matter of it are same, it was discussed where after February, it was decided that the in-charge deputy does not confer the scale of except entitlement of charge allowance.
Yes, lordship.
Therefore, they may be allowed to draw charge allowance. You are entitled to charge allowance.
Yes, lordship. That may my prayer is simple, lordship. My case may be
That you
placed
want the
before-
charge allowance.
Yes, lordship.
My lord,
That is approved, lordship, by the mayor. in
there is
council.
something different. There is something different. Now the additional affidavit says these two
No,
persons.
Mr. Bora, on the last occasion also, when I said that the charge of a deputy commissioner does not entitle her to the scale of
Lordship.
deputy commissioner, then also you were present on the very day, and she said out there that there is some notification to that effect,
Yes.
that they are entitled to a charge allowance. So we dispose it of with the direction that they pay, because this is your decision, isn't
This
this?
this is not a notification. This is a mayor in council meeting. Here, these are these two persons. Lord will turn to page now.
No,
44.
lordship, all together. It is, I already mentioned this all together, lordship. They are giving to all the deputy commissioners, lordship, because all the posts are managers,
regarding
in
two
charge
persons.
deputy commissioner, lordship. I have written in the whole paragraph, lordship, there.
Chalo, no problem. Wait, let me take it. Heard, miss, your name?
K.A. Pujari, lordship. K.A. Pujari.
K. Pujari, the learned counsel appearing on behalf of the petitioner. Mr. S. Bora appears
the-
on behalf of
All the rest.
all the respondents. The petitioner herein issue notice making it returnable on when. Don't delay the matter. Today is 15, we'll have it on 24th. GMC is down the line.
I have to get the
Just,
instruction.
no, you are only to find out as to whether the person is entitled to the charge in terms with these minutes. Is it being given to everybody?
No, it's given to.
Oh,
Yes, yes.
is it given to everybody? You get your instructions on that.
Lord.
Issue notice making it returnable on 24th of May 2023. As the respondents are duly represented by Mr. S. Bora, extra copies of the writ petition be served upon him during the course of the day. The case of the petitioner herein is that the petitioner has been given the charge of the office of the deputy commissioner of a particular zone. Although the writ petition has been filed claiming the pay scale of the deputy commissioner, But during the course of the hearing, the learned counsel appearing on behalf of the petitioner has drawn the attention to the additional affidavit filed on 11th of May 2023, wherein the minutes of the 16th mayor in council meeting held at the conference hall West Boragao GMC office on 28th of March 23 has been enclosed. A perusal of the said minutes, more particularly at serial number 8 and 9, reveals that that there was a decision taken to the effect that a person who is given the in charge deputy commissioner is not entitled to the scale of the deputy commissioner except the entitlement of the charge allowance. The learned counsel for the petitioner submits that the petitioner's claim in respect to the instant writ petition be limited only to the charge allowance. The respondent, the learned counsel for the respondent shall apprise this court on the next date as to whether the petitioner would be entitled to the charge allowance. Yes, Mr. Katunia.
Timing at
This
2.
matter of Mr. Borua,
I think this part
this is the Dhemaji.
Dhemaji district.
Now 2008 till 2007, August 2017, he has received his salary.
Yes.
Now his prayer out here in this writ petition pertains to claiming of salary for the period from 2017 onwards, 2007 onwards.
7 orders.
Now, you see, in the decision which was taken out there, apart from the 7250 teachers who fell in the, apart from 8470 teachers who were in category 3, you added the Dhemaji people also.
Yes, 752 of Dhemaji district.
And he comes within the ambit of Dhemaji. Now, after doing the Dhemaji thing,
Yes.
there was a decision taken on the basis of the salary
Yes, madam.
and the qualification. If he had the qualification prior to 2011, then in that case, he is entitled to the teacher, and after that, he is entitled to the tutor. Now, the petitioner herein claims to have received salary till 2007. Now, thereafter, what decision has been taken in this matter? You just find it out.
Yes, ma'am.
Okay. Heard Mr. M.J. Borua, the learned counsel, appearing on behalf of the petitioner. Mr. Borua, you kindly look into my judgment in the case of Junu
Devi.
Devi.
Sorry, Junu Das.
Junu.
Junu Das.
There you get the whole of all these appointments, how this has happened. So therefore, I remember by heart what is happening. And Mr. Khatunia knows and Mr. Sharma knows. And so the learned counsel for the petitioner, Mr. N.J. Khatunia, appears on behalf of the respondent number 1, 3, 4, 5, 6, 7, 8, 7. Mr. D. Bora appears for the respondent number 2, and who appears for the respondent? No finance today. Okay, none appears for the finance department on call. And none appears for the treasury officer, Dhemaji, on call. Good stuff. Issue notice making it returnable. When can you run? 1 month?
Yes, ma'am.
Issue notice making it returnable on 16th of June 2023. As the respondent numbers 1 to 7 are duly represented, extra copies of the writ petition be reserved upon the learned counsel representing the respondent numbers 1 to 7 by 17th of May. As regards the respondent 8, the petitioner is given the liberty to serve an extra copy upon a standing counsel of the finance department. The case involved in the case of the petitioner herein is that a petitioner was appointed by the then Deputy Inspector of Schools on 19/12/1989 as an assistant teacher. Subsequent thereto, the petitioner continued to render his service. However, since 2007, August 2007, the petitioner have not received his salary. Being agreed, the petitioner is therefore before this court. Isn't that?
My lord, yes, but is my lord, two petitioners, my lord, all are ladies, my lord.
Huh?
Here, two petitioners, my lord. Petitioner,
How many petitioners are here?
two, my lord.
Court fee?
40 only 60, my lord.
Huh?
40 only 60, my
Okay.
lord.
The petitioners, the case of the petitioners herein is that the petitioners were appointed in the year 1989 by the then Deputy Inspector of Schools of the Dhemaji district. The petitioners continued to render service however, from the month of August 2017, their salaries have not been paid. Under such circumstances, the petitioners have approached this court. On the next returnable date, the learned counsel appearing on behalf of the respondent elementary education department shall apprise this court as to whether the petitioner as to whether the petitioners are entitled to the salary from 1/8/2007, as well as whether any decision has been taken in the case of the petitioners pertaining to the cabinet decision on 7/10/2020 to accommodate the petitioners as teachers or tutors, as the case may be. Next. Before parting with the record, it is relevant to take note of that although the claims of the petitioners are distinct and different from each other, however, the court fee of only one petitioner have been paid. Mr. M.J. Borua, the learned counsel for the petitioner, submits that he shall do the needful.
Obliged.
I am telling you, this court fee is going to increase. No. This court fee is going to increase. Once it increases, it will go manyfold. You will be more in trouble. So tell you all of your colleagues also. So all these court fees which are there, those have to be paid, because tomorrow, if it goes to 100 or 200 rupees, now this is 50. Now 200 rupees means 4 times. So if, in this case, it may not matter much. Another 400 rupees, the 200 rupees may have to be put. But in many cases, it would. So tell your colleagues also. It's a move by the government. Yes.
Obliged.
5.
Your lordship recall, it's a similar matter as to those claiming career increment.
Oh, that one.
Yes, madam. Here the proposal is not there, but there's one letter at page 31. The director has asked for the regularization order and the pass certificate of the DLA.
So that day I disposed of matters, 2-3 matters.
Yes,
You were there on that day. You were the person
Yes.
concerned. That matter.
In those matters, both those matters, there was a specific proposal. specifying
Here, no
the,
proposal.
specifying the time and the amount. Here there is no proposal. But
There the figure was fixed,
Yes.
11,91,790. But nothing to the here.
No.
Well, you should notice then,
Right.
Mr.
please, sir.
P. Verda as the learned counsel appearing on behalf of the petitioner, Mr. N.J. Katonia appears on
1, 2,
behalf
3.
of
Elementary Education Department.
the respondent numbers 1, 2, and 3. You should notice making it returnable on 31st of May. You can get the instruction.
Yes,
No,
my lord.
no, I think some more time. Leave it on 12th of June. You should notice making it returnable on 12th of June. As the respondents are duly represented, extra copies of the petition be served upon them by 17th of May. The case of the petitioner herein is that the petitioner is entitled to the annual increment,
Area increment.
which have been given to various persons similarly situated. By the state authorities. The respondent shall apply this court on the next returnable date as to whether the petitioner would be entitled to the area increment benefit.
Obliged.
Supplemental is item number 59 for motion.
Yes, please, your lord.
Yes.
As by direction of the honorable court, I have impaired with the registry.
No Assam rural.
No, there is no.
Fantastic. Now tell me,
Only PNRD has been looking into.
PNRD doesn't react. Mr. Devnath is clear on that.
Madam, I also did a cross checking and I was told that we are supposed to be appearing in all.
Oh, now you are appearing.
It will be for all the respondents.
Very well. Now tell me, what is this
What is the petitioner?
Jivika Sakhi? Your case is that without any notice, nothing has been done. No?
Lost.
They have terminated you.
First, temporary suspended. I have been placed under suspension temporarily. Thereafter, withdrawn temporarily, and focus notice was issued by the director of state mission director. Thereafter, I have submitted focus notice, focus reply.
Then what remains?
Thereafter, I am verbally informed that I have been suspended, but no communication has been made with me, and I have submitted thereafter 2 applications, petition before the director of state mission.
Are you in the state of suspension or are you in the state of termination?
I am suspended here,
Not terminate.
not terminated. Petition I have submitted, your lordship, 36 2021 and 11.
So you are challenging the suspension order?
Lord.
Suspension order, on what basis are you challenging?
Lordship, I am not directly challenging the suspension order. Lordship, first I am placed a temporary suspension. Thereafter, withdrawn the suspension. That suspension has been withdrawn, and I am directed to work as per terms and conditions.
Show me that. First is the office order.
Page 13,
Now
your
what is
lordship,
page 12?
12 is the suspension order, temporary suspension.
Financial irregularity amounting to rupees 3,20,000.
Correct.
Okay. Then
Thereafter, next page, your lordship, page 13,
conditional withdrawal of temporary suspension.
Correct.
In
This is
connection with
still
that,
in
you
force,
have been
your lordship.
temporarily suspended from her works and directed to repayment of rupees so and so, 14/9/2020. Then,
Focus notice.
if your husband is found involved, misbehave with so and so and so and so, you always keep books of accounts of the receipts, and I direct you to return the same to etc.
Yes, 14 focus notice.
But where is the, let us read page 13.
Lordship.
I would like to inform you that you will continue your assigned work only weekly meetings and
Okay.
BO meetings from so and so. You cannot
Cannot
involve in
involve in
so-and-so
RF,
blank
AF and
leaders
bank
and
linkages
so-and-so, and your honorarium will
You
be
return
released
AF.
after getting clearance from so-and-so, and you always keep books of records of so-and-so at your home. In this connection, I direct you to return the same. This is for so-and-so. Then
Lordship,
a show cause has been issued.
page 14, Your Lordship.
Therefore, you are hereby show cause as to why you should not be discharged from AIR. Your explanation should be received within 3 days.
Sir.
Then you gave
Reply here.
reply. Then,
Thereafter, no action has been taken. Whether I am suspended or terminated.
but you have not received your salary.
No,
Are you still working?
no. I am verbally informed that I should not enter into official. From 2011, January from 2011,
11 or 21?
2021, sorry. Your Lordship. After submitting my reply, I am barred to work as typical.
So prior to that, you worked
Work.
from?
From 2018, Your Lordship.
No. Did you work from 9/10 2020
Lordship.
to 18/12 2020? Did you work?
Lordship. I have the know.
Now kindly read 18/12 2020.
Focus.
Yes, no, read it. With respect to the above mentioned subject and from the report received from the so-and-so dated so-and-so, a complaint has been received against you of misbehavior. So this happened pursuant thereto, withdrawal.
Lordship.
So this is a fresh one.
No, Lordship. This is
What is that? It is there. It is dated after that. That is why you have been again so cause.
Lordship, focus. I have submitted my reply, but thereafter no communication has been whether I am again suspended or not.
Okay. Heard, Mr.
P. Rahman.
P. Rahman, the learned counsel appearing on behalf of the petitioner, Mr. N.K. Dabnath, appears on behalf of all the respondents? All the respondents. Good stuff. Issue notice making it returnable. When can you get your result? Instructions?
3 weeks, ma'am.
Okay. Issue notice making it returnable on 9th of June. 9th of June 2023. Steps bit as the respondents are duly represented by Mr. N.K. Dabnath, extra copies of the petition be served upon him by 17th of May 2023. The case of the petitioner herein is that pursuant to the show cause dated 18/12/2020, and the reply submitted by the petitioner on
That is not there yet.
reply submitted by the petitioner thereto, the respondent authorities have not taken any action on the same, and petitioner is not aware as to her status of her employment. The respondent authorities shall apprise this court on the next occasion, next date, as to what course of action have been taken by the respondent authorities pursuant to the show cause notice dated 18/12/2020, as well as what is the present status of the employment of the petitioner.
Hello,
60.
Yes, Mr.
Yes, sir. This is your last way, you are asked to file an additional affidavit regarding the date of birth and superannuation of the petitioner's son.
So what is the date of birth?
Date of birth, your lordship,
When was he supposed to retire?
supposed to retire your 25/3/19, your lordship 34/2028. 304/2028.
304/2028.
20.
You are supposed to retire.
Retire.
Okay. So your case is you come within the ambit of, you are the mother?
Mother, yeah.
You come within the ambit of 5.10. That's your case. And you have approached the respondent authority, they have not given any value to what you have done. Who appears for the respondents?
Department is
Joyab Ahmed, wife.
quite, yeah.
None appears. Higher education. None appears for the higher education. Heard Mr. S. Islam, the learned counsel, appearing on behalf of the petitioner. Mr. None appears on behalf of the higher education on call. Mr. Esa Burua appears on behalf of the Director of Pension. That is respondent number 5. Mr. B. Chakraborty appears for the Accountant General Assam. That is respondent number 2. None appears also. None appears for the Treasury Officer Borpeta. Issue notice making it returnable on 14th of June 2023. As the respondent numbers 2 and আগতে 3 আৰু 6 এপিয়াৰ কৰা নাই বুলি কব দেই 9 এপিয়াৰ পৰা লাষ্টত 3 আৰু 6 কৈছে না 3 and 6. As the respondent number 2 and 5 are duly represented, extra copies of the writ petition be served upon the said respondents. In respect to the respondent numbers 1, 4, the petitioner is given the liberty to serve extra copies of the writ petition upon Mr. K. Gogoi, the standing counsel of the Higher Education Department. And as regards the respondent number 3 and 6, the petitioner is given the liberty to serve copies upon Mr. R. Borpuzari, who represents the Finance Department. In respect to the respondent number 7, steps be taken by way of registered as well as usual. The case of the petitioner herein is that the petitioner is the mother of late Qazi Abdur Rahman.
No, yeah. Qazi Moinul Haq.
Qazi?
Moinul Haq.
Qazi Moinul Haq, who who died in harness on
26/10/2018.
26/10/2018. It is the case of the petitioners that in terms with the government, it is the further case of the petitioner that her son, late Qazi Moinul Haq, would have retired if he would have been alive on
304/2028.
304/2028. And therefore, the family members of late Qazi Moinul Haq would be entitled to compassionate family pension in terms with the government notification dated 14/9/2017. Referring to clause 5.10 of the said office memorandum. The learned counsel submit that if the parents or other eligible family members are not looked after by the compassionate family pensioner, comma, on receipt of such complaint, the competent authority shall issue orders apportioning the compassionate family pension appropriately among other eligible family members. In respect to the said, taking into account the said clause 5.10, the petitioner had also submitted a representation to the secretary to the government of Assam Higher Education Department on 12/4/2023. But however, the said respondent, the said authority, have not taken note of the said representation. It is under such circumstances that the petitioner has approached this court. The respondents in the higher education department is directed to apprise this court as to what steps have been taken pursuant to the representation dated 12/4/2023, and more so as to whether the petitioner, who is the mother of late Qazi Moinul Haq, would be entitled for apportioning the compassionate family pension in terms with clause 5.10 of the government office memorandum dated 14/9/2017. List according.
Interim period not to discuss the salary and character.
What?
Interim period may be considered because
Get
otherwise
it. When is the next date we have got it?
14.
Next date? 14. Wait.
Item number 6 and 7 for admission.
Yes, what is this matter, Mr. Counsel?
My lord, the petitioners were appointed as trainees in Oil India prior to its nationalization, and however, they have been denied pension according to the old pension scheme, and they have been asked to take pension under the new pension scheme. My lord,
They have been denied the pension as per the old pension
My
scheme.
lord, there was a pension scheme that was applicable to employees who were employees that were in the company prior to nationalization, and a new pension scheme that was brought in, a contributory pension scheme that was
Okay.
brought in for employees that had joined subsequent to the nationalization. My lord, the petitioners had joined as trainees, as graduate engineer trainees, my lord, prior to nationalization. All of the petitioners had joined prior to nationalization.
Oh, that pension fund.
My lord, it is but separate from those petitioners, we are on a different ground.
Huh?
We are on a different standing, my lord. Those petitioners were on temporary employees, whereas we were appointed as trainees under the promise, under knowing that we'll be promoted as into the executive cadre, my lord. So,
You were on probation.
my lord, we were as trainees, my lord. It was a prerequisite.
What is this trainee business?
My lord, employed before becoming.
Show me your appointment order.
My lord.
That day I was taking up some matter pertaining to ONGC also. They also have the same problems. Huh?
There is also Oil
I have
India
a
Limited.
order, my lord. Similar matter of oil pension fund matter, my lord. It was decided by you.
Has already decided one. Lordship has already decided one matter in respect of court regarding Rule 8 clause 6.
4110.
Oh, that matter, same matter.
No, my lord. But here we are on a different footing, my lord.
Okay. So these I have referred it back to the authority to take a call on that, because as to whether they will come within the ambit of this. No, I'm not saying about this. There is also another matter pertaining to ONGC. So these people, there were no pension at that point of time. Whether they would come within the pension fund. Anyway, tell me.
My lord, there were advertisements made in the additional affidavit, affidavit in opposition that was filed.
No. First, show me where your case. Let us go into the advertisement later or whatever may be later on. Who are you first?
My lord, actually, okay. My lord, the
Petitioners were
appointments are also in
appointed
the additional
as
affidavit.
where? Where's your appointment?
My lord, it's in the additional affidavits, page number 56. Affidavit in opposition, page number 56. My lord.
Affidavit in opposition, page number 56. Yes.
Prior to that, actually, my lord, it's in page number 35.
Huh?
35, my lord. Same affidavit in opposition, page number 35, my lord. Appointment as graduate engineer training. It was in pursuant to an advertisement that was called for, and they were appointed as graduate engineer.
We are
training.
writing with your reference to the interview held on recruiting a man. Are pleased to advise that you have been selected for training in our area for a period of 2 years. The appointment will be governed by the Apprentice Act, while the second will be governed by the contract. During the period of training. Okay, then.
Subsequent to this, the nationalization happened, and but prior to this, after the appointment, their provident fund and family pension fund, all those deductions were being made from their salary.
But what right do you have on the basis of this?
My lord, subsequent to that, they were all appointed as executive cadre. Now, my lord, according to
then
according to the old pension fund, my lord, if provident, the requirement for being a member of the old provident fund was to if I may read out, my lord.
Where? You're reading from where?
My lord, affidavit in it's in another affidavit in reply, my lord, that was filed by the petitioner.
No, Mr. Counsel, if you want to do the matter, you have to be, you just can't roam around from here to there.
My lord,
You have to show me where.
My
First of all, your appointment as of now is a trainee.
My lord, as a trainee.
You have shown me that.
My lord.
And that trainee does not absorb you unless you pass the written test.
My lord.
So there the matter ends there. Now, whether you have passed the written test or not, you have not shown it to me. Why you are going into from here to there? How many years of practice you are having?
I apologize, my lord.
How many years?
My lord, since 2021.
Oh, then I think you should better prepare this matter.
My lord, if I may just.
You are playing with the lives of those with only 3 years of practice.
My lord, if I may just.
You can't jump around from here to there. First of all, after the training, where you have been absorbed,
Lord,
show me that.
In the affidavit in opposition, page number 66, my lord.
Show me that. Page number 66.
My lord,
okay. We are writing to reference to Aviation India having the pleasure of appointing you as the drilling engineer in the executive bay. Where was the earlier one? Here, 31, this one, and on May, just immediately after. Appointment is effective from 25th June, from which date you will receive the basic salary. Okay, now then.
My lord, after that the petition.
Does this order say anything about your pension or anything?
My lord, this order does not, my lord. However, it says that all the payments will be, all the benefits will be given. However, my lord, in the fund, there was a.
You will be eligible to join the company's provident fund scheme.
My lord.
What about a pension?
My lord, so that was the requirement, my lord. If you have been joining the provident fund, you are automatically supposed to become a member of the oil pension fund, my lord.
Is it so?
My lord.
Now let us see. Your date of appointment is will come into effect from 25th of June 1982.
My lord. However, for all purposes, my lord, their pension fund and pension fund deductions were made from their appointment as GET. Well, that is relevant as graduate engineer trainees since the date of.
No. As of now, as you could be seen, it is from June 2000, 25th June 1982. You have been brought into the executive cadre.
My lord.
Now show me the pension fund.
My lord, if I may take you to the writ petition, page number 54.
54.
Well, this was a list that was maintained.
What is this?
There was a
List of pensionable executives.
My lord.
Yes, tell me.
That was maintained by the Oil India.
From the date of joining.
My lord, since the date of joining. But
From the date of initial appointment.
Yes, my lord. Since
on initial appointment was made on
81, my lord. 81 and 8.
No. If we are going to consider this to be proper, kindly see page 54 of that document you are referring to. It says Ghana Gogoi is 16/6/1981. His date of appointment as graduate engineer training is 24th of May 1981. How do you explain this period?
My lord, that was when he first got his pay slip, my lord. When he first got his pay slip.
Okay, so from the date of pay slip.
My lord.
Okay, so it was not taken on the basis of the executive cadre.
No, my lord. It was taken from the date
Okay,
of.
then next.
My lord, may kindly peruse in Annexure 1. Is the new trust fund that was created by Oil India, my lord.
Show me the eligibility member.
My lord.
Member shall mean an employee of the company who has been admitted as a member of the fund in accordance with the rules, but shall not include an employee who has been admitted as a member, has subsequently retired, or has ceased to be eligible for membership as hereinafter prescribed, or whose services have otherwise been terminated by reason of dismissal.
37(8), rule, page 37, rule 8A, my lord. Employees
37.
Who were, page 37, my lord.
Employees who were members of the existing fund will automatically be admitted to the membership of the fund.
My lord. My lord, that is the name of our claim, my lord.
Who are not a member of the existing fund but otherwise eligible upon confirmation for members. Okay, so
my lord,
what is your case?
I would like to draw my lord's attention to the Burma oil pension rules that existed before, because we are claiming that we are members of the existing fund itself.
Of the Burma?
My lord.
Where is it?
My lord, it's in the affidavit in reply we have filed against the additional affidavit in 3175. Page number 7, my lord.
Seven one?
Page number 7, my lord.
7.
My lord. It's the affidavit in reply to the additional affidavit.
Sorry, Mr. Counsel. This is not happening in this manner.
My lord, it's in flag D, my lord.
Flag D. Here he doesn't have an affidavit in opposition in 5.8.
No, it's in 317517.
You are referring to 3175.
My lord.
Why were all along referring to the other petition?
My lord, both the petitions are on the same
You
ground.
can't keep on jumping from here to there.
My lord, I apologize, my lord. We are
No. Yes, tell me.
My lord, if I may read, the following employees shall be members of the fund. Persons who enter in
page 7.
My lord.
Yes.
My lord, may I read, my lord? The following employees shall be members of the fund. persons who enter into a specified category of service with the company as detailed herein after the first date of January 1973, and who are member of the Burma Oil Provident Fund or Provident and Insurance Fund India. And we have been, our provident funds have been deducted. It has been agreed to by the respondents as well, my lord. And my lord, point number
They deduct the provident fund. Were you members of the Burma Oil Provident Fund?
my lord, because our provident funds were being deducted, my lord. We would have become, because my lord, point number rule number 2 may be taken.
So your case is that as you were members of the Burma Oil Provident Fund,
my lord,
as on
we would have become, my lord, because our provident fund has
now
been
you are coming
deducted.
to we would have. Yes, Mr. Chaudhary, what is the case of the petitioner? I can't make head or tail from the petitioner account.
My lord, the petitioners claim that, my lord, there are two funds, two pension schemes. My lord, one is, my lord, Oil India Pension Fund, under whom they are claiming, and we say that you are not entitled to that. You are entitled under Oil India Supervision Benefit Scheme Fund. So these are two different pension funds. And we have also shown, my lord, two of the petitioners have already taken that benefit. Out of the 12 petitioners, two of them have already taken the benefit, and others are also entitled to the same manner. And so far as, my lord, their entitlement, my lord, may I take your lordship to the, my lord, the date is very crucial, my lord. Date is 14/10/1981. That is the date when that acquisition takes place, and the, my lord, the Oil India was nationalized, my lord. And they were employees not of Burma Oil Company, they were employees of Assam Oil Company. And therefore, my lord, the Provident Fund membership that my learned friend has shown, that will also not be, my lord, taken into account. My lord, may I take your lordship to the, my lord,
which petition?
3125 of the 3125 of the 3175 of the.
Yes.
Now their claim is under, my lord, Oil India Pension Fund, that your lordship will get at page 29 of the writ
Page 21.
29 of the writ petition.
You just tell me what is the date of this nationalization? 14/10/1981.
Yes, ma'am. That is the crucial date.
Nationalization of
that act, my lord, the
of Oil India, na?
Yes.
Now you're referring to
page 29, under which they are claiming.
Yeah.
May I read this relevant provisions, my lord? This is Oil India Pension Fund.
And what is this at page 21? That's the trust deed.
That is the trust deed.
Okay. Then
that came into being on 30th of August 1982, my lord. After the
trust deed.
Right.
Trust deed of
30th August 1982.
1982. So as on this date, the petitioners were brought within the ambit of the executive cadre.
That is, my lord, after the nationalization. Their appointments are after this, my lord, this crucial date.
After the nationalization, but before this trust deed came into being.
Yes. Yes.
Now let us see what are the provisions here.
Now 1AC, your lordship may read. 1AC at page 29. Clause C. C. The fund shall be deemed to have come into operation on and from the 14th day of October 1981. From that,
you are referring to page
29 of the report.
Page 29. The fund shall be established on the trade of so and so. Be established in India, and trustees shall be resident of here. The fund shall be 1C.
Yes, ma'am.
To have come into operation on or from 14th date of October 1980. Yes,
that is the crucial date. Then your lordship will come to clause 2E, the beneficiary. Beneficiary shall mean any individual presently or prospectively eligible for benefit payable under the rules, and shall include a member as hereinafter defined. So, my lord, to get benefit of this, my lord, they have to be prospectively eligible and shall include a member.
Hmm.
Now, my lord, your lordship may come to next page, clause J and K. Clause J is former employee, clause K is member. Former employee means a person who was an pension employee of the company and was a member of the fund as at the date of his retirement from the services of the company. So that requirement they do not fulfill. Then, my lord, K, member. Member shall mean an employee of the company who has been admitted as a member of the fund in accordance with the rules, but shall not include an employee who, having been admitted as a member, has subsequently retired or has ceased to be eligible for so. This part your lordship may skip. Then your lordship may kindly come to
Member means who have been admitted as a member of the fund in accordance with the rules.
yes, I will refer to the rules.
Okay.
Before that, your lordship may kindly come to next page at page 31, internal page, clause O, service.
O.
Service shall mean continuous and unbroken service with the company as an employee and shall include the period of authorized leave. Services shall also include services rendered with the erstwhile Assam Oil Company Limited. Now, my lord, your lordship may, they did not have any unbroken service, my lord. I'll come to that, my lord, showing their appointment letters.
There was a broken service.
In fact, my lord, they were appointed as, my lord, trainee. After the completion of training, there was a selection case. After the test, who were eligible, who qualified in the test and interview, they were appointed after that crucial date. So they were not employees, regular employees prior to this nationalization.
And there was a break.
There was a break, my lord.
Because if you see at page 34 of the petition of this person concerned in the earlier petition, the appointment order date is sometime in May 1981.
June, my lord.
Huh?
June. May and June.
No. It was in May.
The order that he has referred to, yes, my lord.
As a training, it was in May.
Yes.
But it was for a period of 2 years.
Yes, my lord.
But on 25th of June, they were brought into the executive category.
Yes.
Meaning thereby, if it was for a period of 2 years, if that probation period is being taken as a part of the job, then obviously it is continuous.
No, what I mean to say is, my lord, after the selection, after the, my lord, their training period was over, thereafter there was selection. Only thereafter they were appointed regularly.
So you say that from 25th of June 1982, they were brought in.
Yes.
Not prior to.
Not prior to.
Prior to, they were just a trainee.
Training.
And
Training, they were getting stipend. Then they appeared in the text and they got successful. Thereafter, they were brought in.
And clause 4 and 5 categorically say they will be only entitled as per the apprenticeship.
Yes. Yes. So they were apprentice with my lord. Now, your lordship may kindly come to the same rules, my lord. Page 35. Membership.
Yes.
8A. Employees who were the members of the existing fund will automatically be admitted to the membership of the fund.
Now, existing fund has been defined.
Existing fund.
Existing fund is the
No, my lord, that has not been defined.
But fund has been defined as the Oil India Pension Fund.
Yes, my lord, which came into being on my lord August 30th of August 1982, given effect from the my lord that crucial date.
So existing fund is some other fund.
Existing fund is, my lord, that Burma Oil Company fund, my lord.
So this has to be read on the basis of what you call this particular clause Yeah. Now, what do you say at page 22? The trust deed. Kindly see. Second paragraph.
Whereas the company has been securing pension or pensionary benefits in respect of the employees of the company through Burma Oil Pension Fund, a fund established for the benefit of the employees.
No. Hereinafter. Refer to as the existing.
My lord.
Hereinafter refer to as the existing. So
fund.
this is the fund.
Yes, ma'am, that is the fund.
Yes.
Burma Oil Company.
Yeah. So people who were employees or members of the existing fund, that means the Burma Oil India Pension Fund would be members of.
Then clause B, a employee of the company as on 14th October 1981 who was not a member of the existing fund but was otherwise eligible upon confirmation for membership under the rules of existing fund may make an application to the trustees in such form as may from time to time be prescribed by the trustees, and such application shall be submitted at the registered office of the company accompanied by such evidence of age, etc. On such application being approved by the trustee, the employee shall be admitted as a member. So firstly, my lord, they were not members of the my lord existing fund, but my lord, this gives some leeway to them for applying for membership. Then your lordship may kindly come to page 37, my lord. That is the benefits.
So employee of the company as on 14th October, means as on the date, it is crucial date, who was not a member of the existing, not a member of the Burma.
Yes.
But was otherwise eligible upon confirmation for membership under the rules of the existing fund may make an application to the trustees in such form and may from time to time be prescribed with trustees.
And on this point, my lord, your lordship, the other case that my learned friend was referring to, your lordship has sent it back to the authorities whether they can, because they have to apply within a period of 2 years. But now, my lord, 38 years.
This is on 8B, because what was submitted, contention of the petition 8B does not distinguish between a temporary or a permanent employee. It is the further submission of the learned counsel for the petitioner when a member of a company is eligible under confirmation for membership under the rules of the executive, he has to be given the benefit under OF. So and so that an employee in terms with 8B of so and so would mean either an existing employee of the company on so and so who was not a member of the existing fund or probation, who upon being confirmed as. Now, this was a case of a probation.
Yes, my lord. These facts, my lord, do not tally with our facts.
Because there the distinguishing feature which made that normally
they were
an appointment is being made, a person is always kept on as probation. Once the probation is clear, he dates back to that.
Yes.
But in the instant case, that would not apply because of the fact that they were had to pass a written examination, and clause 4 of their appointment order makes it clear.
Quite true.
That's the case.
Yes. Yes.
Nothing more.
My lord, I have. Now, my lord, I'll show, my lord. Now, my lord, if your lordship may kindly come to, my lord, page 35. Thereafter, my lord, there are a set of rules. Rule 11C.
11? 11?
No, 11. My lord, that may not be relevant. Your lordship may kindly come to our additional affidavit.
No more. This nothing is to be seen here any further. No. Additional affidavit.
Additional affidavit filed on 23rd of October 2019.
23rd of October to let's see. Yes.
I'll just show you, my lord, to satisfy your lordship about their nature of appointment. I'll just compare, my lord, two appointment orders. One is at page 9.
Yes.
This is, my lord, dated August 27, 1980. That is prior to the crucial date. And this was issued by the Oil India Limited, not, my lord, Burma Oil Company. Therefore, my lord, Vermeil company does not come into picture. And this is, my lord, appointment as graduate engineer trainees.
Yes.
There, my lord, conditions are there. Under the Apprentice Act, they'll get their, my lord, their service will be governed subject to their clause 4. Subject to there being suitable vacancies, you will be considered for employment in the executive cadre of the company on probation for a period of 6 months. This is, of course, subject to your qualifying in the test referred to in paragraph 3 above. So, my lord, after they completed the training, then, my lord, appointments were made, my lord. This I am comparing with respect to the same, my lord, person, Arvind Jaini at page 9, and, my lord, the same Arvind Jaini at page 12. This is the appointment letter made on March 29, 1982. May I read it?
March. You are referring to page 12?
Page 12, my lord, on date, my lord, March 29, but, my lord, it was issued on 23rd of June, 1982. That rubber stamp.
This is the executive trainee scheme.
My lord.
This is the executive trainee scheme.
Yes, my lord.
No, but here the petitioner was appointed in 1981.
1980, my lord.
81.
81, there is an order of appointment that my learned friend referred to.
But this scheme has come only in 1982.
Yes, my lord.
How is it relevant?
No, my submission is that, my lord, after the this, my lord, after this test were held, my lord, under the trainee scheme.
But this scheme happened later on.
Scheme came into being, my lord.
You see the date, 29th of March 1982.
Yes, my lord. But it was issued on 23rd of June, my lord.
Maybe. So it must have been further after that.
It was prepared.
But their rights, as regards of whatever right, if any, could accrue in 1981. Because 81 they were appointed as trainees. So it couldn't have been on the basis of this scheme.
But this scheme, under this scheme, my lord, this was a fresh appointment under the scheme, my lord.
It couldn't have been, because you see, kindly come to page, I don't know where that file is. The petitioner, you see the earlier petition.
Yes, this petition, my lord.
The 5845. Kindly come to page 34 of your affidavit. I am saying 35. 35. R3 Kohli.
Your lordship is referring to the affidavit in the other affidavit.
Yes.
Our affidavit, my lord.
I hope you are respond number 123 Oil India.
Yes, yes.
Kindly see the date. This is of 24th of May 1981. Page 35.
This is a, my lord, graduate engineer trainee. Yes.
Yes. So this is the training which has happened.
Yes.
Kindly come to what, as per clause 2, the first year of your appointment will be governed by the Apprentice Act.
Yes, fine.
While the second year will be governed by contract with the Oil India. During the period of training, you will be paid a consolidated stipend of so and so.
Yes.
Now kindly come to paragraph clause 4. The continuation of your training after the first 12 months will depend on your performance.
Yes.
During that period. Nearer completion of a total of 18 months training, a written test and an interview will be held to assess your suitability for absorption into the company is in the executive cadre.
Right.
This is, however, now this is relevant. This is, however, without any obligation on our part, I suppose, to absorb you in our organization on completion of the period of training.
Right.
Meaning this is totally segregated. That
Yes.
unless you pass the written test,
Yes.
nothing, you are not going to give it. And this aspect of the matter can be seen further if you see his appointment at page 66. this person's appointment. We are writing to you. Now this, although clause 4 says that after 18 months there will be an examination. But within 1 year itself, this has happened. We are writing to you with reference to your recent interview. We had the pleasure of appointing you as a driller in executive grade B in the drilling so and so. Appointment is made effective from so and so, from which date you will receive a basic salary of so and so.
Your worship is referring to page 56,
66.
I'm sorry.
This is the same appointment order which was made in respect to the same person, which is there at page 35.
Yes, my
35 is for the trainee and this is for the year.
This is what I'm referring to, my lord.
Yes.
July 29.
But it was given effect from 25th June 1982.
Yes. In page 56, my lord, we have referred to the exhibit training scheme, that type copy, my lord.
But this has come only in the March 1982.
Yes, my lord. Yes.
But this executive training scheme is in respect to, but these persons were appointed as an executive trainee, graduate engineer trainee on 81.
In fact, my lord, that point, my lord, we have referred to in our affidavit in opposition at page paragraph 25, page 11.
Of this affidavit itself?
Yes. Yes, my lord.
Paragraph 25.
25 at page 11.
Yes. Post the
nationalization of the respondent number 1, the respondent number 1 company devised a new executive trainee scheme, and the engagement of the petitioners as graduate engineer trainees were superseded by fresh offers of engagement made to them under the new executive trainee scheme by the respondent number 1.
Okay. So what is the difference?
A higher fee scale.
If your lordship takes of this, my lord, and then your lordship may kindly come to the last page of our additional affidavit.
Of the earlier one?
No, this additional affidavit, yes, my lord. In WPC 3175.
Additional affidavit?
Additional affidavit.
Yes.
Your lordship may will get a chart at page 69.
29, you have filed it. Let's see. Yes. Last page.
Last page, man. Page 69. Now, my lord, in respect of the 12 petitioners, this chart has been prepared. Now, they are entitled under this, my lord, EPS 95, and their total monthly pension they have to receive, my lord, last column 9, last but 1. 81,000. This is per month, my lord. 67,000 and odd. Now your lordship will find, my lord, the petitioner number 7 and petitioner number 9. They have drawn pension under OABS, and they have, my lord, drawn the amount. And these rest of the petitioners, except, my lord, the widow at serial number 18, my lord. There your lordship will
serial
find,
number?
My lord, petitioner number 18 is, my lord, her husband has expired, so it was there, my lord, as the petitioner. After the date of the pensioner, balance ROC amount of rupees 3,67,066 was paid after deduction of the excess pension of 3,322 and paid by LIC under EPS 2 further widow pension of rupees 30 is being paid.
So what are you trying to show for here?
My lord, I am showing their entitlement regarding the, my lord, the pension, monthly pension. And that, my lord, three
No,
of the
but here the petitioner's case is that he was a member of that Burma, that whatever provision fund or whatever it may be.
Yes.
And that was duly mentioned in a particular document compiled by the Oil India Limited. And being a member of that provident fund, the petitioner is entitled to be considered for the oil pension scheme, isn't it?
that is the case.
His case.
Yes,
Now,
our
if
case is that, my
you are
lord,
showing this document on the page 69, on the basis that they are now presently getting this as per the second or the third scheme,
Yes.
if I'm not wrong. There were three schemes. Huh?
three schemes.
They are now getting under the third scheme.
Yes, my
So under such circumstances, they are getting. But whether they are entitled as per the old scheme,
yeah, that is the issue, my lord.
that is the issue.
Yes.
So for that, in the earlier litigation, the question was as regards probation.
Yes.
The probationer would be different, if I'm not wrong,
Yes.
from a person who had been appointed as a trainee. So if a person has been appointed as a trainee, could he have the same? Maybe they have included them as a, yeah, but it only says as a member of some existing fund. Now, his reference is Rule 8. Employees who were the members of the existing fund will automatically be admitted to the membership. That is okay. But
my lord, that is with regard to the, my lord, persons who are serving under the Burma Oil Company.
Or for that matter, if we can see from the trust deed itself, where the company has been securing pension or pensionary benefit in respect of employees of the company, the company will be company. Hereinafter referred to and having its registered office to Burma Oil Pension Fund to be an existing fund. So earlier, these members of the company were getting the benefit under the Burma Oil Pension Fund.
Not these persons, my lord. They
No,
are,
no.
they are employees of the, my lord, Burma Oil.
No. Kindly come to page 22 of the petition. You get an answer. I'm coming in 5 minutes because what they are referring out here is nothing to do with because they, in the first part, they define what is a company. The company has been defined to mean the Oil India Limited having its registered office at Duliajan as the company. So if that be so, then you see the second paragraph, whereas the company has been securing pension or pensionary benefits in respect of employees of the company, means the Oil India company, through Burma Oil India Pension Fund, hereinafter referred to as the existing fund. A fund established for the benefit of the employees of Burma Oil Pensionary and of the employees of the associated companies. Just looking. Yes.
I have understood your lordship query, madam, regarding that All India Pension Fund trust deed. Paragraph 2, your lordship was reading at page 22, madam.
Yes.
Whereas the company has been securing pensions or pensionary benefits in respect of the employees of the company through Burma Oil India Pension Fund, hereinafter referred to as the existing fund, a fund established for the benefit of the employees of the Burma Oil Company India Trading Limited and of the employees of the associated companies. My lord, to answer to your lordship query, my lord, may I take your lordship to the Act of 1981? Because, my lord, this throws light on the, my lord, how the employees will be transferred.
Because also page 29 of that affidavit.
The fund shall be deemed to have come into operation from
No, F.
F is the company. Company shall mean Oil India Limited and its successor or assigned or any company or body corporate which may be purchased or amalgamation, acquire or take over in whole or in part the undertakings of the company and with the previous approval of the commissioner undertake to perform the application of the company under the trust deed and rules.
So therefore, an employee of the company has to be meant as an employee of the Oil India company.
Yes. All India. Yes. Now, my lord, if your lordship kindly takes up the act, my lord.
Where is the text? This is Burma.
Burma Oil Company acquisition of shares of Oil India Limited and the undertakings in India of the Assam Oil Company Limited and the Burma Oil Company India Trading Limited, Act 1981. May I take your lordship to the, my lord, the preamble to the next page. An act to provide in the public interest for the acquisition of the shares of Oil India Limited held by the Burma Oil Company Limited and for acquisition and transfer of the right, title and interest of the Assam Oil Company Limited, the Burma Oil Company India Trading Limited in relation to their undertakings in India, and thereby to secure that the ownership and control of crude oil and gas produced by the Oil India Limited and of the crude oil, gas, petroleum products produced by the undertakings in India of the Assam Oil Company Limited and of petroleum products marketed and distributed by the state undertakings and the undertakings in India of the Burma Oil Company India Trading Limited are so distributed and placed to serve the common good. Now, my lord, your lordship may kindly come to section 11.
Yes.
Section 11 is under chapter 5 relating to provisions of the employees. May I read it, my lord?
Yes.
Section 11. Transfer of service of existing employees of the specified companies. Every whole-time officer, I'm stressing on the word whole-time, officer or other employee of a specified company who was immediately before the appointed day employed by that company in connection with its undertakings in India, and every whole-time officer of the or the other employee of a specified company who was immediately before the appointed day temporarily holding any assignment outside India shall, on the appointed day, become an officer or other employee, as the case may be, of the central government or the concerned government company, hereinafter referred to as the successor government company, in which the right, title, and interest of the specified company in relation to its undertakings in India have vested under this Act and shall hold office or service under the central government or the successor government company, as the case may be, on the same terms and conditions and with the same rights to pension, gratuity, and other matters as would have been applicable to him if there had been no such vesting, and shall continue to do so unless and until his employment under the central government or successor government company is duly terminated, or until his remuneration and condition of service is duly altered by the central government or the successor government company. Now, subsection 2. Subject to the rules made in this behalf under section 22, every whole-time officer or other employee of Oil India who was immediately before the appointed day employed by it in India, and every whole-time officer or other employee of Oil India who was immediately before the appointed day temporarily holding any assignment outside India shall, on and from that day, continue to be an officer or other employee of Oil India on the same terms and conditions and with the same right to pension, gratuity, and other matters as are admissible to him immediately before that day, and shall continue to hold such office unless and until his employment under the Oil India is duly terminated, or until his remuneration and condition of service are duly altered by that company. Subsection 3 will also be relevant. If any question arises as to whether any person was a whole-time officer or other employee of a specified company, or as to whether any officer or other employee was employed wholly or mainly in connection with the undertaking of that company in India immediately before the appointed day, or whether or any whole-time officer or other employee of a specified company was temporarily holding any assignment outside India, the question shall be referred within a period of 2 years from the appointed day to the central government which shall, after giving an opportunity of being heard to the person concerned in the matter, decide in such a manner as it thinks fit and shall be final. Now, my lord, in our repetition, we have taken a ground that the petitioners did not come with clean hands. They had suppressed material facts. For instance, my lord, when my learned friend was arguing, he was referring to my affidavit in the opposition rather than his repetition. Because, my lord, the fact that they were trainees, that was not disclosed in the repetition at all. It is only, my lord, when we came and showed that, my lord, they were not appointed, my lord, they were only trainees earlier, and their appointments were subsequent. So this was, my lord, we have taken a ground in the
No. Here the petitioners have come, whatever may be, the petitioners were employed as trainees by Oil India. So they were not appointed by the specified companies. Specified companies have been defined in this act
Yes.
to mean Burma Oil Company or Assam Oil Company and all. The petitioners' appointment were made by the Oil India.
Yes.
They were appointed as trainees. So if you see 11.2, there are two things mentioned. One is a whole-time officer or other employee.
Other employee, my lord, temporarily holding any assignment outside India,
who was immediately before the appointed day employed by it in India, and every whole-time officer or other employee of the IMA who was immediately before the appointed day temporarily. So they were appointed in India also. If you see this 11.2, subject to the rules made in this behalf under section 22, every whole-time officer or other employee of Indian Oil India,
yes,
who was immediately before the appointed date, that is 1410,
yes,
employed by it in India,
yes,
and every whole-time officer or employee of Oil India who was immediately before the appointed date temporarily holding any assignment outside India shall on or from that day continue to be an officer or other employee of the Oil India on the same day, same terms and conditions as with the same rights.
my lord, my substance will be they were not employees of the Oil India Limited. They were, my lord, trainees under the Oil India Limited. And
so that is what I have been telling you from the first. You see, the different thing is here the petitioners were not brought within the service of the Oil India, which is completely different from which was there in the other case.
yes,
They were appointed as a probationer.
But they were on employment.
A probationer may be a temporary employee.
Yes.
A probationer, but once the probation period is finished, he attains the year of a permanent employee.
And that comes to effect from the earlier date.
But being a trainee, his appointment is only temporary. Not only temporary, he's not even an employee.
He was not appointed employee.
He comes within the ambit of this Apprentice Act or whatever may be, or even a contract, which have been given in his terms of employment.
That is our case, my lord. In fact, my lord, if I may take your lordship to the, my lord, the order of appointment at case, my lord, 102, no, that the rationalization, my lord, at 102 of our affidavit in opposition. Affidavit in opposition in the, my lord, the other case, in fact. 584. That was in both there. In this petition also, affidavit also. 102 of any of the affidavits. Page 102. This is a communication dated November 1, 1983 regarding rationalization of fee and perquisites of the executives of Oil India Limited. There, my lord, if your lordship kindly comes to page 105. regarding retirement benefits. There is no change in the provisional fund and gratuity benefits. The existing pension scheme shall, however, be restricted to only those executives on the roll of the company as on October 13, 1981. Now, my lord, your lordship will see, my lord, the relationship between the petitioners and the Oil India Limited is governed by a contract of service. And this has also not been challenged. The conditions which are there in the, my lord, the contract of service, those are also not under challenge. And
Meaning
this was
thereby?
done in,
Now, what do you mean by that?
no, my
What has not been challenged?
my service is that, my lord, when the pay was rationalized and the specific date was given that it will be applicable to the, my lord, persons who were appointed on or on October 13, 1981, as on the roll of the, my lord, Oil India Limited, they will be given this retirement benefit. This clause is also not under challenge.
So you mean this document of 1st of November 1983
is also binding on them.
Has not been challenged by them.
Yes.
But if they consider themselves to be within the rules, only those executives on the roll, so they were not an executive.
So they were not like this, they were not.
And as such, the question of pay getting, it is only given to executives. They became only in the members of the executive after 14.
And service has also been defined, my lord. What is service?
Hmm?
So what is service, that has also been defined, my lord. Your lordship did not go into that. So they were not on the roll of the, my lord, Oil India.
So your long and short submission is, without going into all nitty-gritties out there, 8B entitles only employees. Employees will only mean those people who are officers or executives of the company in the roles.
Yes.
It would not extend to trainees, which were in respect of which the petitioners, the relationship between the petitioner and the Oil India were only to the effect of a trainee. Be that there may have been some deduction on provident fund that is immediate, but they were not employees of the
Oil India Limited. Yes, that is the long and short of the case.
Now, yes, tell me.
My lord, the rationalization letter that is effort we have also annexed in the request. It is.
I'm not concerned on that. First of all, your appointment was for a trainee. For that 1 year, although in the month of March, 29th of March, which was given into effect from June, 23rd of June, 1982. These people, the petitioners herein were brought into the area of executives. Prior to that, even if before the scheme of executive training came into effect, your relationship was only as a trainee coming within the ambit of the apprentice. That was your appointment letter.
I would like to first point out that the company had taken a 3-year bond from the petitioner. If we were under a 3-year bond from since 1980, or even if we consider 1980, then till after nationalization, we were employees of the company. And since after
No. Bond is a different thing. Bond is another element out there. Bond is only that you are given a, what happens? A person is given out there an opportunity to train themselves in a particular establishment. For getting a training, certain expenditures are being made by the establishment. This establishment, once you, whatever may be, you can't leave the job immediately. So that is the reason why these bonds are being signed. How do you become an employee?
by by submission. My lord, if I may, in the writ petition, page number 89, there are certificates that have been issued to the petitioners, my lord, for different purposes during their service.
It's the council.
In which their date of appointment has been mentioned as, my lord, in the first one it has been mentioned as all have been in 1980, my lord. And my lord, if I may take your kind attention to page 89 of the report.
No, whatever may be. Your appointment order, which was made in the year 1981, were an appointment order in the capacity as a trainee. You don't come within the ambit of a employee.
Well, but the fundamental rules, Rule 9 says that if what
fundamental rules, how can a trainee come into the aspect of that?
Well, it says that service as a probational apprentice, provided that such service is followed by duty, followed by confirmation, would mean duty. So he was in service, he was in duty with the Oil India, and the acquisition act says,
For a person, even he is in the apprentice also. Let us assume this. And then it is a confirmation. Then you will be entitled to, what does it say?
That it would fall under the definition of duty, my lord. Which means that we have been in duty with the Oil India since prior to nationalization, my lord. And
then why didn't you challenge your appointment order, which dates back only till 25th of June 1982?
Because we were under the assumption that we would.
No. There cannot be an assumption or presumption, because it was, the order was clear. Didn't the order say your appointment, although it was given in the month of July or August, would date back only till 25/6/1982?
But the Oil India company was considering our services from prior to nationalization.
I'm not on that. That appointment order makes it clear. You have accepted that appointment order. You have never challenged in the year 1982.
That appointment, the prerequisite to that appointment was the training, my lord.
No. Prerequisite of that appointment was the written examination.
There can be no other way in which a person can become an executive apart from the training.
No.
And all
there is, see, your appointment order as a trainee, clause 4 says that you have to appear into an examination after 18 months.
Yes, my lord. And all the petitioners.
Now, only thing, because by virtue of this other training program, which this another circular which was issued as regards the executive training, there it has been mentioned only to the effect that within 1 year they would take it. Earlier, it would have only happened after 1.5 years. But that order of your appointment in the year 1982 makes it very clear that your appointment has been dates back only from 25/6/1982.
My lord, but the executive engineer training that we had undergone, that was also in pursuance to an advertisement in which we appeared, and then we were given appointment letters as graduate engineer training.
Whatever may be, why haven't you challenged it then?
My lord, because we
you should have challenged it. No, our appointment should date back from there.
Yes, my lord.
Now, after all these things, in the year 2023, you come up with all these things.
My lord, because we were in the pension rolls, my lord. Our names were appearing. We have been given certificates that we are members of the pension fund. And suddenly, when the eldest of the petitioners had retired, then we were informed that we are not part of the pension fund. If we were always been said to be part of the pension or Oil India pension fund, we had no idea that we were going to be excluded, my lord. It was always under the knowledge that our period of service as graduate engineer training would be considered. But suddenly, my lord, they have decided that it is does not fall under the category of employment. We were bona fide employees of the company, my lord.
Now, how can you be bona fide employees of the company on the basis of just the training?
Yes,
and there was categorically, it was observed in paragraph number 4 that the appointment out here would not mean that you have been, there is a requirement that you shall be absorbed.
Well,
it is subject to the passing of the written examination.
Well, but the Acquisition Act does not state whether that trainees are a specific class. Trainees are also employees, my lord, as per the Acquisition Act. full-time officers or other employees. And we fall under the category of other employees. And it clearly states in my lord, section 12 of the 12.4, my lord, 12.3, my lord, that the successor government companies fund will not diminish the rights of any of the whole-time officers or other employees. Now, my lord, if we were
But
other
how can you
employees,
be an employee?
my lord, what other category can we fall under, my lord?
A trainee?
My lord, trainees are not even
Trainee
considered.
can't be an employee.
Yes, my lord. If we are
Show me something to show that a trainee can be an employee. Show me a particular precedent to the effect that a trainee can be regarded as an employee.
well, here refer to a Bombay High Court judge. That's a process. Paragraph 8.
Yes.
It states, in our view, non-addition of the aforesaid training period to the petitioner's regular service has resulted into great injustice to the petitioner, as it is clear from the record and regular posting order was awaited and his apprenticeship was not terminated and his case was kept on waiting list for giving appointment order, and therefore it was only an administrative delay. In view of the same, even if TCS pension rules are not applicable so far as the railway employees are concerned, the petitioners even gets the benefit as per the board orders, which I had quoted above. Since it is not in dispute that the railway board, that part is relevant by the but trainee is not being considered, the court has held that it is perhaps improper.
Step up.
It is not per se on same track.
Per se?
But
This is in respect to an interpretation being given to rule sub-rule 3 of rule 22, wherein it categorically mentions that rule 22 of CCS rules and the government of India instructions issued on the subject from time to time provide that a period of training can be counted as qualifying service for the purpose of pensionary benefits if the training is immediately followed by appointment. So it is in that perspective the court has said, show me a particular provision to the effect.
In that case, my lord, may I be granted one day, sometime, my lord. I will try to convince your lordship.
My goodness, you have spent how much time?
I understand, my lord.
Then?
I apologize, my lord, but one opportunity might
Yes, your name?
My lord, R.B. Goswami. R.B. Goswami.
R.B. Goswami. Mr. R.B. Goswami, the learned counsel for the petitioners in both the writ petitions. Mr. M.K. Chaudhary, the learned senior counsel, is assisted by here on behalf of the Oil India Limited. The case of the petitioner herein is that the petitioner, having been appointed as a trainee, what trainee is that?
Graduate engineer training.
Having been appointed as a
Graduate engineer training.
appointed as a graduate engineer trainee prior to 14/10/1981. They would be employees within the meaning of section rule, is it rule or clause? Clause 8B of the Oil India Pension Fund. And as such, they would be entitled to pension in terms with the Oil India Pension Fund. On the other hand, Mr. M.K. Chaudhary, the learned senior counsel, by drawing the reference, submitted by drawing the reference to the orders of appointment as graduate trainee, submitted that such appointment would not make the petitioner employee within the meaning of rule clause 8B of the Oil India Pension Fund. Referring to clause 2 of the order of appointment as a graduate engineer trainee in respect to one of the petitioner, the learned senior counsel submitted that first year of such appointment would be governed by the Apprentice Amendment Act 1973, while the second year will be governed by a contract with the Oil India Limited. He further submitted that clause 4 of the said order of appointment would also show that pursuant to completion of 18 months of training, a written test and interview will be held to assess the suitability for absorption in the company in the executive cadre. It was also made clear in clause 4 that there was no obligation on the part of the company to absorb on completion of the period of training. Further, referring to the orders of appointment of the petitioners as drilling engineer or production engineer, as the case may be, the same were made effective after 14/10/1981. And as such, they were not, and as such, the petitioners herein cannot be said to come within the ambit of the term employee mentioned in rule clause 8B of the All India Pension Fund. Further to that, the Learned Council has also drawn the attention of where is that rationalization thing? Additional affidavit at
Yes,
page,
my lord.
Petition page 47.
102.
page
102 of the affidavit in opposition.
102. Further to that, the Learned Council, Senior Council, drawing the attention of this court to the rationalization of pay and perquisites of the executive of Oil India Limited, dated 1/11/1983, has drawn the attention to clause
1.9 at page 105.
1.9 and more particularly to clause 1.9.1, wherein it has been mentioned that the existing pension scheme shall, however, be restricted to only those executives on the rolls of the company as on 13th of October 1981, and the executives who joined service on or after 14th of October 1981 will not be entitled to the benefit of the pension scheme. The Learned Senior Council further submitted that the petitioners at no point of time have challenged their orders of appointment into the executive cadre, as well as also this particular document dated 1/11/1983, wherein it has been categorically mentioned that their appointments were made after 14/10/1981, and such officers would not be entitled to the old pension scheme. The Learned Counsel for the petitioner submits that he requires some more time to prepare for the matter. Accordingly, list the matter again on when? No, it's not convenience of it. You have taken so much of time.
Yeah.
On 26th of June 2023. ভয় দিব, হ্যাঁ?
I'll let.
Eight.
Yes, Mr. Nair.
Physiology. This matter, my lord, we are home guards deployed in the NIPCO, my lord, in the Kopiti High Project, my lord. We are being paid salaries, our wages, my lord, at a much lower rate than our counterparts, my lord, who are from other states. My lord, what we are on, my lord, is if my lord comes to
What you are asking for?
my lord,
Pay parity.
pay parity, my lord,
Wait,
with the other counterparts from other states
other state.
who are deployed in the same project. Well, I have given an example.
You are home guards under
In NIPCO, deployed in NIPCO, my lord, in the Kopili High Project.
from any state are paid minimum rate of wages fixed by the whichever is higher during the time. Yes.
In fact, our cases were
Now you are claiming pay parity with whom?
my lord. My first prayer, my lord, would be with the other home guards from other states of Meghalaya, Mizoram, Meghalaya, Tripura, who are deployed in the Kopili project. Secondly, my lord, or with the lowest of the pay scale granted to a constable in Assam.
Constable.
constable. So, my lord, that is as per the Supreme Court judgment, my lord, in the my lord.
Jagjit Singh.
No, my lord. Rakshak, Home Guards Welfare Association versus Himachal. There was a there was a direction to all states, my lord.
You have paid the deficit court fee?
Yes, my lord. Okay. My lord, may come to para 39 of this, the last page. 39, last paragraph, second last paragraph. In view of the discussions made above, no relief can be granted to the appellants either for regularization of service or for grant of regular appointments. Hence, no interference is called for against the judgments passed by Himachal Pradesh, Punjab, and Delhi High Courts. However, taking into consideration the fact that home guards are used during emergency and for other purposes, and at the time their duty are empowered with the power of police personnel, we are of the view that state government should pay them duty allowance at such rate total of which 30 days a month comes to a minimum of the pay to which police personnel of a state are entitled. It is expected that state
No. These are home guards appointed by whom?
Appointed, my lord, engaged by the government of Assam, my lord, but deployed in NIPCO, my lord. We are Assam home guards, my lord. NIPCO has home guards from different states, from Tripura in the same project, my lord, from Tripura and Meghalaya as well.
They are getting more.
They are getting much more. When the writ petition was filed, my lord, we were getting around 10,000 rupees. A person from Meghalaya.
So NIPCO home guard.
My lord.
These home guards are appointed by the state government.
By the state.
And they are being deployed at various installations of NIPCO. Now in Meghalaya, an installation in Meghalaya, that home guard is getting more than what is being given out here.
In the same installation as well.
Same installation. By the state, by their state government.
Well, payment is made by NIPCO.
Why NIPCO paying?
Sorry, my lord.
The NIPCO has to pay.
NIPCO has to pay because they are engaged in duties in NIPCO, my lord. Okay. NIPCO stand, my lord, in their affidavit is they are paying as what the state government decides. The state government stand is they have enhanced from time to time. My lord, our salary was around 10,500 rupees per month. I have annexed the pay slips. A person from Meghalaya, my lord, he was getting 20,600. I have annexed the pay slip. More than double at the time when the writ petition was filed. Now it is much. One of the central government stand, my lord, is that they ought to be paid minimum wages as per the central minimum wages because NIPCO's appropriate government would be the central. The Central Labour Commissioner has also filed its affidavit.
What in this case, what they were asking for?
Well, pay parity with that.
In this case, also in the Supreme Court?
In the Supreme Court, they were asking for regularization.
They were asking for regularization. And this regularization, they have been given the pay parity.
Pay parity.
It's something also in the case of another case, no? Upendas. The case of regularization and they ended up in pay parity.
But in fact, the state of Tripura has also, my lord, written to NIPCO to pay as per the lowest of the scale of the constituent.
But has the Supreme Court out here decided how a functionary of a police constable would be same that of a home guard?
My lord, in this paragraph itself, it says.
No, it doesn't say so anything.
My lord, were used during emergency and for other purpose, and at that time, their duty, they were empowered with the power of police.
Understood. You see, there are many differences out there. A home guard may not have the same responsibilities and duties which is there for a police person. So under such circumstances, merely because the Supreme Court has just stated in paragraph number 39, without taking into account that aspect of the matter, would it be proper on the part of this court to just shut its eyes and just follow it as per paragraph 39?
I would fall back on the central minimum. On the central minimum. The appropriate government for NIPCO, my lord, is the government of India. If it is the government of India, then the central minimum wages apply in NIPCO. Since we are engaged in NIPCO, the wages which we ought to be paid, my lord, has to be as per the central, which is much.
So that is a different aspect,
Yes. In fact,
which is not touching on this.
in fact, I have annexed those.
No, understood, but that is on a different line. Because in very recently, the Supreme Court was taking note of the engineer, the doctors under the Ayurvedic, the homeopathic, as well as also the allopathic.
They're much less.
Very recently.
Yes, ma'am.
And the Supreme Court said, no, you can't, because these are the functions of them and these are the functions.
These are different.
So for employing the pay parity without a proper discussion on that, yes, arbiters of the Supreme Court are also to be followed, but would it be applicable here?
My lord, here that in this case, my lord, the central minimum wages need to be paid during their time of deployment.
That makes more sense.
My.
Yes, central government. Central, yes. You have a central minimum wages.
Yes.
Now, when you have the central minimum wages, it means a notification is issued under Section 5 of the Minimum Wages Act. Yes. You must be stating out there categorically that for these things, this would be the minimum wage. Now, whether NEPCO would be bound by that?
My lord, we have filed our affidavit, my lord.
Yes.
That is in case number.
Affidavit is okay, but I am asking you a specific query as to whether the NEPCO would be bound by that.
NEPCO is my lord come under the central government because under the central government minimum wages act, my lord.
So they will come.
Yes.
So when a central government issues a notification being an appropriate authority or appropriate government, NEPCO would be bound by that?
Yes.
That's your case?
Yes, my lord.
Yes, ma'am.
Yes, my lord.
Now, then in that case, irrespective of who gets who, the moment they are deployed, would NEPCO be bound by to pay that?
Yes, my lord.
Now, let us see in your affidavit where you have said the yes.
That is, my lord.
Affidavit filed by respond number?
Respond number 87819, my lord.
Okay, let us see that.
From Terra 4, my lord.
The government of India enterprise along the state home guards have been engaged in the scheduled employment of watch and ward in the end and the of paid by the family. There exists the employer and initially notified the rate of minimum wages. So in paragraph number, this long.
Yes, paragraph number 1.
Long.
Page 4.
Long.
Start from
Paragraph
page
6.
Yes, ma'am.
Although it's a very long paragraph, but in long and short, your stand is that you being the appropriate authority, you have rightly directed them to pay this amount. So they will be entitled to the central minimum wages of watch and ward. It has to be paid. Irrespective of who asks what about to be paid is not material, but they are to be paid that minimum wages. Which are they paying? Are they paying?
No, my lord. No. Much less.
Yes, Mr. Senebut.
Your Lordship, with regard to the affidavit filed by the central government, 8, 9, and 10, we were not served a copy. And we are, because now they are taking a stand that NIPCO is liable to pay. I need to file a counter to that. Subject to 9.
It was filed on 15th of March 2022.
They filed. They didn't serve a copy to upon us.
Understood, but why haven't you taken that plea earlier when the matter has come all
Because we
the
had
time?
no knowledge. No, it came on a
It
very-
came on the last occasion on 27/3/2023 when we
Yeah,
asked the
we-
petitioner to make all this payment.
But subject to that, your
Oh,
Lordship.
on the last occasion you did not appear. Oh, appeared.
My
SOD
colleague,
appeared.
yes.
Then
But
you have
your
been-
Lordship, subject to that, the point here is that admitted position is that they are under the Home Guards Act. A Home Guards Act, they are voluntary members. Now, whether they are an employee, first of all, the question that will come for your Lordship consideration is that whether they are an employee. And only in the
No. Minimum wages act is paid to whom?
employee.
Is it?
Yeah, there has to be an employee-employee relation.
No, is it?
Yes, Your
Employee,
Lordship.
employee. Minimum wages is paid to whom?
And second issue, your Lordship, here, the labor inspector of respondent number A, they have filed a claim petition before the regional labor commissioner. There we have, in respect of the same writ petition. In that, we have filed our response saying that we are not liable to pay as per the minimum wages act because they are home guard, we are paying as per the direction issued by the state government with regard to the pay fixed by them, honorarium pay, duty allowance pay, fixed by them. Now, the regional labor commissioner, who is adjudicating the matter there, has now filed an affidavit apparently here, taking a stand that we are already liable, without even hearing us, without even passing an order to that. Now
Mr.
that
Senebati,
proceeding has gone.
Mr. Senebati, we are not concerned what he does or what he does. That is another aspect of the matter.
Because that also
I'm
I have
only,
challenged.
no, Mr. Senebati, I'm only concerned out here as to whether the petitioners out here would be entitled to the minimum wages act as has been mentioned by the central government.
In that
Now, if I am not wrong, for the purpose of minimum wages,
yes, Your
do you
Lordship.
require an employer-employee relationship
Yes,
for
Your Lordship.
appointment?
There has to be an employer-employee relationship.
Is it so?
Yes.
Then
And
no, tell me, what basis are you saying it is to be an employer-employee relationship?
In that event, sir, why wasn't the state government also not paying the minimum wages?
I'm not concerned with the state government. I'm concerned with you. I'm asking you a specific question. What is the basis on which you are saying that it has to have what basis there has to be an employer-employee relationship?
Because I have to be an employer, first of all, to pay a minimum wage, I have to be an employer. Here, in the case...
Understood, you may be an employer, but employer means what? Are you going to give an appointment letter?
Not appointment. I don't have any control on
You can't engage anybody. You cannot make a person. Do you know the meaning of why the Minimum Wages Act has been incorporated? It is not for anything else. That the moment you engage the services of any person in your establishment, you are bound by that notifications which are being given by the appropriate government to make the payment. The moment you are engaging somebody, there's no requirement of an employer-employee relation to that. Let's look into the case of the tea garden laborers, workmen. These people, there's no appointment letter being appointed.
No, it's not appointed.
But the thing is, the moment you are appointed, you are using their services, you have to pay this. Matter ends
Your
there.
Lordship,
I'll have to defer to that because here's one thing. They are under the Assam Home Guards Act. Now, merely because they've been deployed in NIPCO, forget about any other organization. Does their nature stand substituted from a volunteer member to being a person employed in my organization?
No. That is why you are not paying your cadre rates to them. What you are paying him is the minimum of the wages which you have to pay. There's a difference between that. This is the Minimum Wages Act is only meant for that. I mean, in many aspects of the matter, there may not be an organized sector. There might be many unorganized sector also. Then also, it is the mandate of law that you are to pay this minimum amount to a person when you are employing him for this.
Section 3 says, the appropriate government shall, in the manner herein provided, fix the minimum rate of wages payable to employees employed in an employment specified. They are not employees. I have not employed them. They have merely been deployed by the commandant.
Then don't keep them.
I cannot, because the deployment, the commandant doesn't take them away.
Have you written to them?
It is under the act that after 6 months they have to take them away.
So have you written to them not to keep them?
I have to check get an instruction on that.
Then,
whether we have.
But whenever it is there, you have to pay that. There's no quarrel with that proposition.
And under the act, the state government directs me. Let the state government direct me, because the
no. State government, there's no business out there. With the state government is providing those people out there to watch and ward. As these people have been duly appointed out there to watch and ward. Watch and ward comes within the ambit of the central government for the purpose of you, NEPCO.
Then your lordship, there's just on another side angle. Home Guard is one organization. They have a set of Home Guard volunteers. Now the commandant decides that this person will be deployed here, this person will be deployed. Merely by their deployment in an organization, should there be a discrimination in respect of their wages or their duty? Suppose a person is a Home Guard, is deployed as a traffic constable, and a person, same qualifications, everything, same. He is a member of this, and he is deployed with NIPCO. He gets a higher wages merely because of his deployment in NIPCO. And a person who is Home Guard, who is deployed as a traffic constable or in the High Court, say we also have it, Home Guards here, should he get a lesser wages?
That is for those Home Guards to agitate, not for you. You are to pay that. We are not concerned with all those
things. My submission on this minimum wages.
Yes, pay me. Show me.
My submission, Your Lordship, is that
minimum wages.
Yes,
tell me.
Also, let me also file a reply to this respondent 8. Let me have a stand on this. That the stand taken by the respondent 8, 9, 10.
Yeah, 2018 matter. Does it look nice?
They filed it on 22, Your Lordship, with no copy served
22
on me.
is 1 year back.
Your Lordship, I had no knowledge on the last occasion. I
should have
obtained a
been.
certified copy. I obtained a certified copy.
So you know it then.
No, I got the certified copy on the 31st. Give me some time to
31st
file
of what? 31st of December?
No, 31st of
Don't tell me April.
April, Your Lordship.
For you, the calendar, lunar calendar here has
No,
one
not
additional day
Your
for
Lordship,
April.
just 1 minute, Your Lordship, I'm getting into the date.
Then? Okay, heard Mr. P.D. Nair, the learned counsel appearing on behalf of the petitioner. Mr. D. Sonepoti appears on behalf of the NEPCO. Ms. A. Gayan appears on behalf of the central government. You are appearing?
Okay.
Mr. H. Sharma appears on behalf of the state respondents. Mr. D. Sonepoti submits that he had only recently obtained a certified copy of the affidavit filed by the respondent numbers 8, 9, and 10. And as such, he may be permitted to submit a reply, taking into account the stand so taken that the NEPCO is liable to pay the minimum wages as notified by the central government for watch and ward in respect to watch and ward industry. Taking into account the same, this is the matter when?
1st of June, 2nd of June, 7 is not there.
We'll
7th
have
of
it
June.
on 1st of June, 2023. The the NEPCO is directed to file the affidavit by 29th of May.
Maybe become seventh matter.
Why?
I will not be accepted.
Okay. I know that there is a host of central government council. Ask somebody to appear.
Yes.
Somebody else.
My lord, in this matter, we are supposed to file the affidavit, my lord. We could not file the affidavit, my lord. My lord, we will need at least another 3-4 days time to file the affidavit, my lord.
31.
Next week, my lord.
Lordship,
There are some.
in the meantime, the department has filed their affidavit saying that this that qualifying service is not there, Lordship, for 20 years after deducting that 6 years, Lord, which has already been dealt with by Sanjita Roy case, Lordship.
31.
31.
Yes, affidavit is filed.
Yes, Lord. Filed on, we received on 2/1/23. And judgment, Lordship. Lordship, may kindly see their affidavit, page number 19, Lordship. Their affidavit. Pension in the meantime, the petitioner received, Lordship. Only BCRG and the GPF, Lordship. Regarding BCRG, Lordship, page number 19 may kindly see of their affidavit.
Ms. S. Kanungu, the learned counsel appearing on behalf of the petitioner. Mr. R. Rahul Dhar appears on behalf of the respondent numbers 1, 2, 3. Mr.
KK Methi appearing on behalf of
respondent
respondent
number 4. None appears on behalf of the Treasury Officer on 4th. The case of the petitioner herein is that the petitioner was appointed, that the husband of the petitioner was appointed as a grade 4 employee under the South Kamrup Territorial Road Division, Mirza, Polasbari Public Works Department. The husband of the petitioner. When did he retire?
Lordship,
Madam, your petition does not contain any details. Doesn't contain any details.
Lordship, in their affidavit also they have mentioned, Lordship.
Understood, but why? Your petition does not contain any details.
He was engaged on 26/12/1992, Lordship. And
Nothing is mentioned. No, you are making a case on the basis of the affidavit.
No, Lordship.
Then where's the statement made? When did he? How many years of service did he have and all? Where is it mentioned? For me?
Lordship, in para number 2, Lordship.
Yes. What is it mentioned?
Who expired on 29/11.
No. When did he join?
Joining at that point of time, the wife was not ignorant, Lordship. At that point of time, she was not that much educated, Lordship. That's why.
I can't help you. Petition of such type has to be dismissed. There's no mention, nothing. Tell me. Why should I give you any relief if this is the manner in which you file your petition? Have you mentioned that you have you don't know when your husband joined? Then Nothing is mentioned.
In the meantime, pension.
Then why didn't you file a letter? Write a letter to the court, better off than to file a writ petition in this manner. What is the contents in paragraph number 2? Read it. Let us read. Paragraph number 2, paragraph number 3. Then read it.
Lordship expired on Lordship.
Yes, read it. Let us read it. Is this the manner in which a writ petition is filed? Now you are claiming that a case is covered under Constitutional Roy. This is a case to be dismissed on that ground.
I'll file additional.
लिख ले तो the husband of the petitioner. No, and again, from a perusal of the materials on record, it is apparent that the petitioner's husband, late Manzoor Ali, was initially engaged as a MR laborer on 26/12/1992, but he was later on brought under the regular establishment with effect from 22/7/2005. The husband of the petitioner expired on 29/11/2018. A perusal of the affidavit filed by the respondent number 3, that is the executive engineer PWD, reveals from paragraph number 4 that the total period of engagement of the husband of the petitioner was 25 years, 11 months, 3 days. But 6 years was deducted, and thereby the qualifying service of the husband of the petitioner was taken as 19 years, 11 months, 3 days. On the ground that the husband of the petitioner did not complete net qualifying service of 20 years, the Office of the Accountant General AE did not authorize DCRG to the petitioner as per the rule. It further appears that as regards the GPF, on account of some lapses on the part of the office dealing with the matter, the proposal for withdrawal of the final GPF was not submitted to the AG Assam in time. However, the said proposal have been submitted on 29/12/2022. And it has been mentioned in the said affidavit in opposition that it is expected that the General Provident Fund GPF would be paid to the petitioner at an early date. It further appears from a perusal of the petition that the claim of the petitioner is for release of the death cum retirement gratuity benefits to the petitioner, as well as for directing the respondent authorities to release the general provident fund to the petitioner. So far as the general provident fund and entitlement, it appears from the affidavit in opposition that the same is under process. However, as regards the death cum retirement gratuity benefits, the same has been denied to the petitioner. On the ground that the petitioner's husband did not have 20 years of service after deducting 6 years. The learned counsel appearing on behalf of the petitioner have drawn the attention of this court to the judgment of the coordinate bench in the case of Sanjita Roy and others versus State of Assam and others, reported in 2019 to GLT 805, wherein it was held by this court that a deduction of 6 years, or for that matter, any period to calculate the 20 years of continuous service did not appear to be reasonable. It was further held that the state should not make further classification of master roll workers who have completed 20 years of continuous service by introducing the condition of deduction of 6 years of casual service. Taking into account the said judgment of the coordinate bench of this court in Sanjita Roy and others, Supra, this court also holds that a deduction of 6 years so made by the respondent authorities, thereby depriving the petitioner of the death cum retirement benefit for not completion of 20 years, is illegal and arbitrary and contrary to the law laid down by this court in Sanjita Roy and others. Accordingly, this court therefore disposes of this petition with a direction to the respondent authorities to pay the death cum retirement benefits to the petitioner, as well as also complete the formalities as regards the release of the general provident fund to the petitioner. The same be done within a period of 3 months from the date a certified copy of the order is served upon the respondent number.
Here to be respondent number.
Respondent number 2.
Respondent number 1.
1 and 2.
1 and 2 both.
1 and
Respondent number 1 and 2 separately.
3 also, my lord, because it will initiate from 3.
1, 2, and 3 separate.
For 5, correspondent 5.
So today, none has appeared on behalf of the finance till now. There were many matters where finance were there, none has appeared. There were many motion matters also, the finance are not there. I thought the finance have left it out here. He appears for finance. But madam, be careful next time. This time I have given it, but next time don't expect it.
I know 40 and 41.
What is this matter about?
Well, that Tezpur Law College removal of secretary and the suspension matter.
Item 40 is regarding challenging the removal of the secretary post for the petitioner who is serving as a principal of the college.
Hmm.
And under the ordinance of Guwahati University, my lord, it has to be elected post among the governing body members. But the person who was selected and not elected was not even a member of the governing body.
Let me take up the other matters first. This will take some time.
My lord, can it be on any other day that finalization of the other thing is going on? My lord?
Which one?
That rule, my lord, can be on any other day. Tomorrow also no. Tomorrow, day after.
How do you know that tomorrow the rule making would be over?
Today, maybe, my lord. It will not be over. Thursday, my lord, if not over.
Thursday he has problem.
Okay, sorry. Friday or any day, I'm here. Otherwise,
tell me.
The records are with me, my lord.
What is the scope of challenging the suspension order? Yes. What is the scope of challenging a suspension order?
The suspension was.
They have the power to suspend you.
But my lord, the manner in which I was suspended, my lord, was without any.
As Mr. Das has submitted on the last occasion, the reason for suspension was because you have filed another petition challenging her removal from the post of the secretary.
And calling for a meeting to discuss the writ petition that I have filed, that is item number 40, without any agenda about my financial mismanagement, my lord. And in that case, I refused to attend the meeting because I was the petitioner against them. And they want to discuss my case as an appellate authority.
But don't you think that the power to suspend is there with the employer? It's not a punishment.
But there has to be an inquiry, my lord. At least.
Why? Why there should be an inquiry for a suspension?
My lord, immediate cause has to be ascertained why she needs to be removed, my lord. The outright cause.
No, she's not removed, she's suspended.
Sorry, my suspension.
Then?
The immediate cause was filing of this writ petition, man. In all these years, my lord, I have been serving. There was no acquisition of any sort of financial mismanagement, my lord. And moment I filed this writ
No, if there is a allegation of financial mismanagement, I would have understood if it is a case of termination.
Yes.
Understood. But suspension, don't you think, right from R.P. Kapoor, the Supreme Court has been clear to that effect, and more particularly if you see the judgment of Justice Dr. B. Chauhan in 2013-16 SCC, I suppose.
Right.
The power of suspension is already there, and the scope of judicial review is very less.
Yes, it's limited. But my lord, the very fact that is arbitrary exercise of powers, my lord, for collateral purpose, that has to be looked into. Whole genesis of the suspension, where does it emanate
No,
from?
then why should this court at all interfere, taking into account that Mr. Nair has submitted that within 1 month they are going to complete the period?
It's the resolution. It's the resolution.
Have you looked into the judgment of the Justice Dr. B. Chauhan?
No, I'm afraid, my lord, I haven't.
Let me read it to you. (2013-16 SCC 147). Now here the Supreme Court says the scope of interference by the court with the order of suspension has been examined by the court in large number of cases, particularly so and so, wherein it has been observed that even if a criminal trial or inquiry takes a long time, it is ordinarily not open to the court to interfere in a case of suspension, as it is the exclusive domain of the competent authority who can always review its order of suspension, being an inherent power conferred upon it by the provision of Article 21 of the General Clauses Act. And while exercising such a power, the authority can consider the case of an employee for revoking the suspension order if satisfied that a criminal case pending would be concluded after an unusual delay for no fault of the employee concerned. Where the charges are baseless, malafide, or vindictive and are framed only to keep the delinquent employee out of job, a case of judicial review is made out. But in a case where no conclusion could be arrived at without examining the entire record in question, and in order that the disciplinary proceedings may continue unhindered, the court may not interfere. In case the court comes to a conclusion that the authority is not proceeding expeditiously as it ought to have been, and its result in prolongation of the sufferings for the delinquent employee, the court may issue directions. The court may, in case the authority fails to furnish proper explanation for delay in conclusion of the inquiry, direct to complete the inquiry within a stipulated period. However, mere delay in conclusion of an inquiry or a trial cannot be a ground for quashing the suspension order if the charges are grave in nature. But whether the employee should or should not continue in his office during the period of inquiry is a matter to be assessed by the disciplinary authority concerned, and ordinarily the court should not interfere with the order of suspension unless they are passed in malafide and without there being a prima facie evidence on record connecting the employee with the misconduct in question. Now, you see, it is for this court now, already the matter was filed when?
The matter was filed on 18/1/2023.
Okay. Almost 5 months have gone by.
Yes.
They have said that within 1 month they are going to complete. 1 month of which 10 days have gone. How many? 5 days have gone.
Well, no, the resolution is of
27.
a resolution is of 4/5/2023.
So already 8 days have gone. 4, 5 means 11 days have gone. Only 18 days are left. Why should this court interfere at this stage?
My lord, this was the resolution of.
There was no stay by this court.
No,
No.
we are proceeding.
Obviously, you are proceeding.
We are proceeding.
It was subject to outcome of
So by another 18 days, they are coming up with. Why should this court interfere?
Well, in that case, the matter may be fixed after 18 days. Let them complete it.
What do you say? You complete it?
I'll do.
You said that.
I said, because my lord, because this matter was fixed 4/5, after that the matter was fixed, so the letters could not be issued to the inquiry. Inquiry officer is identified. We'll have to issue a letter to her and to the inquiry officer, and my lord will only give me a 15 days or 20 days time. After that, my lord will fix the matter. We'll have the matter closed.
No,
We'll go day to day.
How many? You have taken the decision on 4/5.
4/5 that we resolves to entrust the president to issue appointment.
We'll have the matter on 5th of June.
And my lord wants me to. We'll proceed.
You said that within 30 days you will complete.
It can be done, but my lord will only make an observation that she will also cooperate with the
12th of June, man. 12th of June, man.
So he has given you 7 more
enough,
days.
my lord. I'll finish the matter. Enough.
Because these are all after first.
Which one?
The whole.
No, understand. No, Mr. Khatone, this court duly understand that. But the problem is
the technicalities.
no, this court is bound by these judgments of the Supreme Court. Unless, you see, interfering now, for example, I interfere with it on the ground of malafide, which is a very high degree of proof is required. Thereafter, the next consequence is, obviously, nothing is going to, they may prefer an appeal, but by the time nothing happens, So it makes no sense. Spoiling the-
And 19th, my lord, when she was said to be removed in that meeting, she was there, my lord, she signed. She was there in her friend, and she was told that, see, these are the things we have just come to our notice. So we are just keeping you away so that we can keep it in it. And the appointment letter that she has brought on record, my lord.
Heard Mr. M. Katuni, the learned counsel, appearing on behalf of the petitioner. Mr. U.K. Nair, the learned senior counsel, assisted by no assistance.
Yeah, man, MP
The
Sharma.
MP Sharma.
Respond number
For the respond number 3.
3, man.
Ms. So-and-so appears for the respond number 5. And you appear for respond number 6. 4. So-and-so appears for the Guwahati University. You appear for 1 and 2. Mr. D. Upamanyu appears for respond number 1 and 2. Upon hearing the matter, the learned counsel, senior counsel appearing on behalf of the respondent number 3 submitted that the university have also already resolved in its meeting held on 4/5/2023 to complete the inquiry proceedings within a period of 1 month. Taking into account the same, as well as the dispute involved herein, this court fixes the matter on 12th of June 2023. In the meantime, the respondent number 3 may proceed with the, in the meantime, it is clarified that the instant, by way of the instant proceeding, this court have not stayed or suspended the inquiry proceedings. The respondent authority shall be at liberty. Respondent university would be at liberty to take such action as deemed proper.
Double I. My lord, it's college. It should go as college, not university, college. Much.
Number 10.
Last order of the directed 10 to take instruction regarding release of the event test.
We require some more time, my lord.
How much?
My lord, 1 week time, my lord. We have already communicated, my lord. On next week, my lord, Tuesday or Wednesday fix, my lord.
But Mr. S. Bora, you have not got the money?
Other relief, they take out.
You have got everything except the leave encashment.
Leave and okay.
The heard Mr. S. Bora, the learned counsel appearing on behalf of the petitioner. Ms. A. Gayan appears on behalf of the CFGC. The instructions as sought for by the order dated 19/4/2023 is awaited as to whether the leave encashment amount has been duly paid to the petitioner. Mr. S. Bora submits that to his instruction, the said amount has not been paid. Taking into account the same, let the matter be listed again on 26th of May 2020.
Master.
Okay.
14.
Yes.
Lordship, in respect of DCRC and pension, I have received lordship. And
You have got the DCRC?
yes, lordship.
Pension?
Pension received lordship. The commutation pension not received.
Huh?
Commutation pension lordship.
Well as the status pertaining to entitlement of the petition on GPF, what has happened?
GPF, I just inquired your lordship. They were supposed to submit certain documents, and I've been told the petitioner he was supposed to actually submit the documents on the 17th of May, this coming 17th of May. So once he submits, then we'll immediately send it to the AG. So AG is also party.
Now he have Now you are getting your regular pension?
I have received a lump sum amount of 8 lakhs and all.
Yes.
Uh,
Have you got the DCRG separately?
they have,
Or the 8 lakhs constitutes the DCRG also?
yes, sir.
Okay.
The competition lordship amounting rupees 6 lakhs and all. Competition of pension. That was already sanctioned lordship. That was not disbursed.
It has already been sanctioned, then obviously it will get it.
Yes, yes, sir.
Then what is this court going to do? This court out here is sitting out here to decide rights, not to facilitate how the payment is to be made. So nothing remains.
Yes. Only GPF, then I'll.
GPF, they are going to do it.
Yes, sir.
I'll pass an order to that effect. Heard Mr. X to Prodhor, the learned counsel appearing on behalf of the petitioner. Mr. R.K. Talukder appears for the Accountant General AE. Mr. D. Bora appears for which department?
1, 2, 3.
1, 2, and 3. And no finance.
And 6 also, Your Lordship.
And B. Gogo appears on behalf of the Treasury Officer Hatsing Mari. The learned counsel appearing on behalf of the petitioner has submitted that the petitioner have received an amount of rupees,
Lordship, 8 lakhs and all.
an amount of rupees 8 lakhs and odd, which constitutes the pension as well as the DCRG. However, the amount pertaining to the GPF have not been paid to the petitioner. On the other hand, Mr. D. Bora, appearing on behalf of the respondent number 1, 2, and 3, and 6, submits that the petitioner have been asked to submit a particular document on 17th of May 2023. And upon submission of the said document, the same shall be forwarded to the Office of the Accountant General AE. And thereupon the petitioner shall receive the GPF. Taking into account that there is no denial to the rights of the petitioner to receive the GPF, and it is only the completion of certain formalities, this court therefore disposes of the instant writ petition, thereby directing the respondent authorities, more particularly the respondent number 1, 2, 3, and 6, to ensure that the petitioner receives the GPF within a reasonable period of time. The said exercise be completed within a period of 2 months.
Your Lordship, from 2 months from date of submission of documents.
2 months from
Date of submission of documents for a petition.
the date. No, what document? You need that document, na?
They completed GPF application.
Within 2 months from the date. You have not mentioned what document.
No, there is a GPF final application form in account number IP/815.
So that is the only document you want.
Yes.
From the date of submission of GPF.
Final application form.
Final application form. Anything more?
So within brackets in account number IP/815. Brackets.
Right. 2 months, huh?
25.
Other in this matter, specific instruction was sought for by the previous order as well as the order prior thereto. We are filing the affidavit today, madam. So hence, madam, it may be fixed up day after tomorrow.
No. What is your affidavit?
The copy, I don't have it right now.
You don't know.
I have one copy.
No, I have asked you a simple question as to whether the petitioner is getting the minimum scale of pay as directed by the division bench in Upenda. That is what her claim is.
Yes, Lord.
Because she has rendered more than 10 years of service.
Yes.
And the same is reflected.
Madam, with respect to that, madam,
With the communication dated 1/2/2018
with respect to that, what instructions I have is that, as far as that is concerned, my lord, only those petitioners are receiving the fixed wages and remuneration who have been appointed in the pre-AFRBM period.
Pre-AFRBM would be 4/7/2005.
And the petitioners have name has not been included there.
So, but when the judgment came in respect to Upendas, that was never an issue.
Yes.
How are you bringing that issue into it?
That is not.
Yes, finance. How are you bringing that issue into this? You, at that point of time when the judgment of Upendas had come, AFRBM Act was there. And that was not that was not one of the reasons or conditions stipulated out there in the judgment to the effect that those persons who are there in AFRBM period or not. It was categorically mentioned that those persons who have been working for 10 years from 1/8/2017 prior to.
Well, probably that is there in the notification that has been issued by the finance department. But to make give me some time to place the notification. Probably my lord, that will have to be put to challenge.
No. Are you saying that the notification issued by the finance department runs contrary to the judgment of this court?
Let me place it, my lord, not to that item. What is there in the notification of 2019? I can place it, my lord, by Friday or because this entire exercise was carried out after the notification was issued by the finance department.
Understood, because that day also Mr. Arbor Pujari was saying that aspect of the matter.
Yes.
But is it me that the judgment has been clear, putting a date on a particular date, 10 years?
Yes.
Meaning thereby, those persons who were appointed even after, because FRBM, if I'm not wrong, came on 4/7/2005.
Yes.
So, but this order is, the Upendas is 10 years from 1/8/2017. Meaning thereby only person who are there from 1/8/2007 also.
No, it will be my lord 10 years from the date of passing of the judgment.
No.
Benefit will be from that day.
Not 10 years from the date of judgment, because judgment is of 8/6/2017.
Yes.
But the order has been given from 1/8/2017.
So benefit they will enjoy, my lord, the benefit from that day.
Understood. So 10 years from back.
Till the date of judgment, the 10 years will be counted, but the benefit, my lord, will be given from August. That is.
So 8/6/2017. There's no quarrel with that.
It will be, my lord, till 2000, say June 2007.
So there might be a lot of people who may not have been the AFRBM Act may not have, they were appointed without taking note of that also.
Post FRBM, my lord, from 7 to.
So if that was not pointed out before the division bench, am I not bound to direct that you have to do so?
Of course, my lord.
More particularly from that document, if I remember that document in the case of that that health department matter.
Yes.
The reason why the AFRBM Act or these aspects needs to be taken is only so that they get their salary. Nothing else.
Fine. To curb the illegal appointment and all.
Legal appointment or no illegal appointment, but they have been this PNR department has certified that the petitioners have been working for the last 10 years. And they come within the ambit of that.
Initially they forwarded my name.
Huh?
Initially they forwarded my name.
Yeah.
Thereafter my name has been cancelled. My appointment is Lordship on 22/06/2005.
2005.
Yes, Lordship.
22?
22/6/2005, prior to the FRBM Act.
Oh. Because AFRBM came only on 4/7/2005.
And it with effect from 1st September 2005.
And yours is? Appointment is?
22/06/2005. My
Prior to that?
Yes.
No, my lord, in the synopsis, my lord, the petitioner was again appointed on 22/9/2005. What?
After the expiry of his father law. Initially his father was ill, then he was appointed on 22/06/2005.
Page 23 and page 25. 23 and 25.
He is walking since.
Regarding a tax collector, illegal, illegible precedent pursuant to the meeting of.
Very good.
Then 25.
25.
No, it's okay. But only thing is, I'm only concerned out here is whether what does the line department say? What is the stand of the line department? What is the name of the petitioner? Baluram Gogoi. Yes. Baluram Gogoi.
No, you will find the certificate in page 27.
Somewhere the name is here.
Page
If I,
number 50, Lordship. My
huh?
name is page number 50.
50, yes.
Yes, my name is in serial number 108.
Huh?
My name is in the serial number 108. Sri Baluram Gogoi.
Yes. Here it is given
Yes, more than 10 years.
22/9/2005.
Here it is 9.
So this is after the AFRB.
Yes, here it is after. And Lordship, one letter, page number 32, Annex F, Lordship, which is issued from Joint Secretary to the Government of Assam, Panchayat and Rural Development Commissioner, PNRD. There, Lordship, two categories.
Okay, we'll do one thing. Heard Miss D. Talukdar, the learned counsel appearing on behalf of the petitioner, Mr. N.K. Dapna, the learned standing counsel appearing on behalf of the PNRD department. Mr. B. Gogoi appears on behalf of the finance department. Mr. N.K. Debna, the learned counsel, submits that in pursuance to the order dated 10/4/2023, the PNRD department is in the process of filing the affidavit today. Mr. B. Gogoi, learned counsel, submits that he may be given an accommodation for a week so that he can obtain the necessary instructions. Place the matter again on 29th of May 2023, on which date the learned counsel for the PNRD department as well as the learned counsel for the finance department shall obtain the instruction in terms with the order dated 10/4/2023. And more particularly, no, further to that, the learned counsel for the finance department shall also apprise this court as to whether, in pursuance to the directions passed by the division bench in its judgment and order dated 8/6/2017 in the case of the state of Assam versus Upendas, the respondent authorities can deny the benefit of the said judgment on the ground that the petitioner's appointment was made subsequent to the coming into effect of the AFRBM Act. Liberty is given to the petitioner to mention the matter for
27.
Please, your lord. In this case, I need 3 days time to obtain instruction.
How much?
3 days.
Why 3 days?
Yeah, PPO already issued. PPO already issued.
Issued.
Lordship forwarded to the Treasury officer and personal copy also received, but
PPO issued, DCRG issued. You've got a DCRG?
no, Lordship, not released.
PPO got. But money has not yet been credited.
Lordship.
Huh? Will be done.
Will be done.
Where is yes, Kitabot Treasury Officer, he appears. He will do it. I'll keeping on this on record. Heard, Miss? You, Hazarika, the learned counsel appearing on behalf of the petitioner. Mr. R. Dhor appears on behalf of the Accountant General AE. Mr. B. Gogoi appears on behalf of the Treasury Officer Titabor. And Mr. R. Rahul Dhor appears for the Sericulture Department. The learned counsel for the petitioner had submitted that the Office of the Accountant General have already issued communications dated 29/3/2023 to the Treasury Officer Titabor, thereby requesting the said office to disburse the DCRG amounting to rupees 1,61,250, as well as payment of pension of rupees 3,210 per month or total,
For
with effect from per month. Yes, per month, no? Per month, with effect from 25/2009 to 31/3/2016, and rupees 7,970 with effect from 1/4/2016 per month, with effect from 1/4/2016. The said communication so submitted by the learned counsel for the petitioner is kept on record and marked with the letters X and Y. So, taking into account the said issue, taking into account that the PPO has already been issued and the Treasury Officer Titabor have already been directed by the Senior Accounts Officer of the Office of the Principal Accountant General AE Assam. This court therefore disposes of the requisition with a direction to the Treasury Officer Titabor to do the needful in compliance to the communications dated 29/3/2023 issued by the Senior Accounts Officer so that the petitioner receives her DCRG, his or her, his DCRG, as well as his area pension and pension. A copy of the the petitioner. The petitioner is further directed to submit a certified copy of the instant order to the Treasury Officer Titabor. Yes, Mr. Sinha.
Yes, madam.
You have seen the order, what he has done?
Just now he has completed.
Okay. Now, in view of this, I think you need to challenge this.
Yes, we have to challenge, but it's not just my question to Madam Chair. It's not a contempt, my lord. Because your lordship has directed on the last petition, by last order, that they should comply with the order. Last order by order dated 13/3/23, where your lordship was pleased to direct to make payment of subsidies allowance for so and so within 45 days. Challenging this, or in substitutions of this order, can they pass such an order? Is it not a contempt, matter?
Now, the inquiry report was given in your favor.
Inquiry report is just pending like that only, without any decision.
No, they say there is an inquiry report.
There is a two inquiry report, whether it's maintainable or not. That is also in my two inquiry report. One inquiry report of
Found all charges formulated against as established beyond any doubt. It is seen from the inquiry report that so and so remained absent in school from so and so to so and so at his own will, and even he had not felt the necessity for submission of any application seeking leave of absence to the school authority or any immediate higher authority. This is also reflected in the executive meeting of so and so dated demand. Unauthorized here is gross negligence of duty and responsibility and violation of the code. The proposed notice was served upon the demand on demand. When was the inquiry report?
inquiry report, one inquiry report by deputy inspector of school.
No,
That is,
by the inquiry officer.
yes, by the inquiry officer.
When was the inquiry report?
1/4/20, my lord, first, my lord.
1/4?
1/4/2023, my lord.
1/4/2023.
Yes, my lord.
Where is that?
My lord, first, the report, the inquiry report in connection to the departmental proceeding drawn up against Takar, a retired assistant from so and so under Dhemaji district, as submitted by the DU under file her letter number dated 1/4/2023.
Where is it? Which para you are reading?
First, second paragraph, my lord. Also read, starts with also read, my lord. 1.
Also read, yes. The letters to the statement submitted by so and so at the time of hearing of practice of the Iman on Iman and the so-called reply submitted before the tribunal. Now tell me, after this inquiry report, did you put him to show cause?
Yes, my lord. Paragraph 3, my lord. Here, paragraph 3, my lord.
Yes.
The letter issued to the petitioner by this office letter number so and so dated 24/4/2023 and 3/5/2023 for submission of written reply against the finding in the inquiry report submitted by the DO so and so 1/4/23 for finalizing of departmental proceeding. He was given opportunity to submit the
when it was communicated.
In fact, he has received also, my lord.
Day before yesterday, it has been served, my lord, through district official. Just day before yesterday. 3 days not yet completed.
He has given
3 days. I have paid for time for another 15 days.
He has given 2 opportunities, my lord. One is for on 24/4/23 and another is, my lord, 3/5/23.
No. Let them come and record that it is served to me, my lord. There's a direct contempt, my lord. They are sitting over the order, they're sitting over this order of this honorable court. Why from that court that power? This court has directed to comply with the order to make payment of subsidies allowance. In spite of that, they did not go for appeal also. Okay,
Now, why haven't you paid the subsistence allowance?
Because of, my lord, that is also there, my lord. In findings, my lord.
Yes.
4th paragraph, my lord.
It is also observed that Sri Takarete did not furnish any application along with non-engagement certificate under provision of FR Rule 53(2) for grant of subsistence allowance during the suspension period. Once he submitted the non-engagement certificate, my lord, we will process it, my lord.
Then you will process.
Yes, my lord. In fact, we have mentioned in the order also, in the last line of the order, my lord.
Yes, to me.
Last line, my lord. The period spent under suspension by Sri Takarete shall be treated as such, and he will not be entitled for any subsistence allowance during his suspension period, in the absence of any claim that he was not otherwise engaged during that period. So if he furnished the non-engagement certificate under FR 53(2), my lord, then he will get it, my lord.
Mr. Sinha, were we engaged during this period?
No.
Then you can submit your certificate.
Yes, ma'am, I can submit.
We will take up this matter later on.
Yes, ma'am.
You just submit this.
Yes, ma'am. Yes.
Because they say out here.
Yes, ma'am. Okay.
And independently, we can challenge this.
Yes, ma'am.
I think that is a better option. Heard Mr. B. Sinha, the learned counsel. I think you bring this by way of an affidavit. Mr. B. Sinha, the learned counsel, appearing on behalf of the petitioner, and Mr. N.J. Khatrunia, the learned standing counsel, appearing on behalf of the elementary education department. Today, Mr. N.J. Khatrunia, the learned standing counsel, have produced an order dated 12/5/2023, issued by the Director of Elementary Education, Assam. From a perusal of the said order, it reveals that the petitioner herein was dismissed from service by the said order. The period of his unauthorized leave from 1/11/1993 till date, he was placed under suspension, have been held to be treated as dies non. It was further mentioned that the period spent under suspension by the petitioner shall be treated as such, and he would not be entitled to any subsistence allowance during his suspension period in absence of any claim that he was not otherwise engaged during that period. The learned counsel, appearing on behalf of the elementary education department, submits that the claim of the petitioner for subsistence allowance during the period from 15/9/1994 to 13/8/2020 have not been totally written off. However, it was on account of non-furnishing of the non-engagement certificate which was required in terms with the FR 53(2) of the FRNSR as applicable to the state of Assam. The said subsistence allowance could not be paid. He further submitted that if the petitioner submits a certificate to that effect, the authorities shall do the needful. Upon hearing the learned counsel for the parties and upon perusal of the order dated 13/3/2023 passed by this court, whereby there was a specific direction issued to the respondent authorities to pay the subsistence allowance to the petitioner. within a period of 45 days from the date of the said order. This court deems it proper that the said order dated 12/5/2023 should be brought on record by way of an affidavit. The learned counsel for the petitioner submits that the petitioner shall do the needful for complying with the provisions of FR 53(2) of the FRNSR as applicable in the state of Assam, taking into account the same. List the matter again on 26th of June 2023 for further consideration.
Right.
The petitioner, in the meantime, the pendency of the instant writ petition shall not bar the petitioner to challenge the order dated 12/5/2023 if deemed fit. The order so submitted during the course of the hearing is kept on record and marked with the letter Y.
Item 37.
Petitioners that are the members of various district consumer forum. And they were appointed, my lord, in pursuant to the earlier rule, my lord. And my lord, some of them were appointed as early as back in 2013.
Yeah, who knows? Why this matter has been updated? The matter update. Yeah, I left. Yes, tell me. You have filed your reply.
My learned, we have not received the copy of the reply.
You have not got the copy. Why? It has been given to somebody from your office of the Government Advocate Assam. You can't get it. Not being supplied to you, how does it make a map? Your case is coming under what?
We have been seeking pay parity because the new members who have been appointed pursuant to the new rules matter. They are getting a salary of about 72,000 per month. Whereas we are getting a daily allowance of 600 rupees plus conveyance of 150 rupees, so 750 rupees per day. So it comes to around 9 to 15,000 per month.
19, 20,000.
9 to 15,000.
9 to 15,000.
Depending on the holidays and all that. So
pay the minimum scale of pay and other allowances in the rank of Deputy Secretary to the Government of Assam.
Yes,
in terms with the Consumer Protection so-and-so model. Who are you?
Well, we are members of the Consumer Forum. We are also
you are members of the Consumer Forum. District. And who are being given more money?
Well, the members who have been appointed pursuant to the new rules.
Or they are getting more money.
More money. We have been continuing under the old rules.
86.
86 rules. No, the Act is 86. 2010 rules was Assam Act 2010 rules. So under that we are getting the per day of 600 rupees plus 150 rupees contents per sitting. As against that, in 2020 the model rules, actually the state government did not frame any rule. They adopted the model rules of the state federal government. Under that,
but you are doing the same work.
Same work, absolutely same, quantitatively, qualitatively, in terms of responsibility, everything.
Yes, Mr. Gogoi. Understood, but the problem arises because of you. The finance causes the problem.
No,
Mr. Bora's department has no quarrel. Otherwise,
no, they are the one who have rejected the claim.
They will reject. They have rejecting because of you. Otherwise, they have no problem. Isn't it?
My lord.
All happens because of the finance causing the problem. Whenever the question of high pay, low pay, whatever may be, all depends on the value. Now, here is a case where the petitioners are similar, are working in the same capacity as members of the consumer forum. As they were appointed under the 2010 rules, they are getting more or less, whereas the petitioner, those persons who have been appointed now, are getting more. Why is this disparity?
There is no such
Well, no, on what basis were you appointed?
My lord, we have appointed, my lord, on the basis of, my lord, there is, my lord, regular advertisement, my lord, and selection, my lord. And my lord,
What is the requirement for getting appointed in
requirement,
this?
my lord, is bachelor's degree, number one, my lord. Bachelor's degree.
Yeah.
And my lord, earlier it was 10 years experience, my lord, in various fields. And now it's 15 years experience under the new rules.
So there's a difference?
No, difference is, my lord, that in the earlier rules, when we were appointed, my lord, so I was appointed in 2013 with 10 years experience. Now on job, my lord, I have got another 7 years of experience. So under the new rules also, I'm qualified.
But are you not asking that those persons who were appointed in 2010 should be equated with 2023?
My lord, because, my lord, the new rules
On the
have-
ground that in the meantime you have gained experience.
that is one factor that makes us eligible for the new post also, my lord. And my lord, under the act, my lord, our earlier appointments have been continued. The act, under the new act, my lord, our appointments have been continued.
Continue
They've been continued
as members.
as members.
But
is under
those
the
other members
Madam.
who are freshly recruited, they are getting more.
They were appointed in 2021. They're getting more. Because these new rules came much afterwards. Right?
Where is the finance? You have not made the finance? Oh, yes, number 5. They are there. Finance? I think you should file an application.
Otherwise, my lord, if the new rule has override the earlier rule, in that case, my lord, they will come under 2020 rule. That is the, my
So
lord.
if your golden words can be put on affidavit,
My
we
lord.
can very well incorporate them and give the benefit to the petitioner. Isn't it so?
Yes, sir.
That is why I asked, I didn't ask Mr. Bora. Because Mr. Bora will later on say, we can't do anything because the finance won't allow.
Because it says this amended rule.
Whatever may be,
My lord, no.
you file your affidavit out there because the problem arises with you.
Yes.
Isn't it?
They control the main part. They control, madam. That's the mother of all.
That day I was taking a matter of Mr. Arup Borbora, and that was a PNRD department. PNRD department said, no. These people should be getting more. But the finance is not. All problems arises with the finance.
Their word is the final word.
Okay. Heard Mr. M. Datta, the learned counsel, appearing on behalf of the petitioner. Mr. D. Bora appears on behalf of the respondent numbers 1, 2, 3, and 4. Mr. B. Gogoi appears for the respondent number 5. The issue involved herein is as to whether the petitioners who were appointed as members of the consumer forums under the what rules?
Well, it is 2010.
Under the
I just read the name. It's the Assam State Consumer Protection Amendment 2010.
2010 would be entitled to pay parity with those members who have been appointed in terms with
Well, Consumer Protection Act 2019 and the Consumer Protection Salary and Allowances and Conditions of Service for President and members of State Commission and District Commission Model Rules 2020.
which have been adopted by the state of Assam. Although the respondent numbers 1, 2, and 3 have already filed their affidavit in opposition, and a reply has also been filed by the petitioner. But this court deems it proper that an affidavit from the finance department would be necessary for the purpose of deciding the matter. taking into account the same, list the matter again on 14th of June.
Well,
So the affidavit be filed by 12th of June.
Keep the plan.
Here I played a lordship may take up this matter in the first week of June, my lord. They are doing the needful, my lord, to give the, my lord, provisional pension to the petitioner. Probably from next month onwards, my lord, they will be getting. That's what I got instruction from the government, my lord, today. After this, so let it be on first week of June, my lord.
Or Mr. MP Sharma, the learned counsel for the petitioner. Mr. B. Gogoi appears on behalf of the Health Department. Mr. A. Hassan appears on behalf of the Accountant General AE. This court, by the orders dated 1/3/2023 and 28/4/2023, and made specific queries upon the Health Department as to whether the provisional pension have been duly paid to the petitioner. Mr. B. Gogoi, the learned counsel, standing counsel for the Health Department's request for an accommodation. This court fixes this matter again on 2nd of June 2023. It is made clear that the petitioner, having not received any provisional pension since 31/1/2018, and if no provisional pension is not paid within the said period, this court would have no other option but to pass appropriate orders against the department.
Let it be on 5th, my lord. At least we'll keep that.
42.
Yes, Mr. Hawk.
Non-payment of family pension method. That was granted by.
Sorry. Yes, school department,
Elementary.
school department. You have made the school department party?
Yes.
Why they are not here? Mr. Katuni, here is a case where the petitioner is not getting the family pension in view of the fact that although the Office of the Director of Pension have been writing to you in the month of March, it seems that you are completely forgotten the plight of the petitioner. Heard Mr. S. Hawk, the learned counsel, appearing on behalf of the petitioner. Mr. N.J. Katuni appears on behalf of the respondent numbers 1 to 4. And I've also heard Mr. S.R. Borua, the learned counsel, appearing on behalf of the Director of Pension. During the course of the hearing, the Director of Pension, the learned counsel appearing on behalf of the Director of Pension, have produced a communication dated 28th of March 2023, 20, wherein the Deputy Inspector of Schools, Guwahati, was requested to submit the following documents. Number 1, family pension proposal along with form number 3, 10, 20, and 21 in respect of Miss Millie Rabha, minor daughter of late Dhananjay Rabha, Number 2, next of kin certificate. Number 3, 3 slips of specimen signature, descriptive role and photographs of legal guardian for onward submission to concerned Treasury Office along with the pension payment order. Number 4, joint photographs of the minor with the legal guardian. It is the specific case of the Director of Pensions that said that the Deputy Inspector of Schools have not taken any steps in that regard. This court further inquired with the learned counsel for the petitioner as to whether those documents have been duly submitted. However, he seems to be not aware about the same. Considering the above, this court fixes this matter again on 21st of June 2023. In the meantime, the petitioner herein shall submit the necessary documents if not already submitted to the Deputy Inspector of Schools at the earliest, so that the Deputy Inspector of Schools, Guwahati, is in a position to send the same to the Director of Pension for the purpose of finalizing the case of the petitioner. The documents so produced by the learned counsel, Mr. S.R. Borwa, is kept on record and marked with the letter X. Mr. Counsel, where will the Deputy Inspector of Schools get your photograph? That is why I'm saying, have you submitted this? You are not aware.
They have not.
Absolutely. Now, therefore, I'm passing this order. So with this order, you go do the needful, joint photograph of minor with legal guardian, 3 slips of specimen. Because if I don't pass this order, tomorrow Mr. Khatonia is going to come and say that the petitioner have not done that. 43. You take this order and do the needful. That is why I mentioned what are the deficiency. Will help you out. Yes, madam.
These are not releasing the arrears salaries during the period of 11/2014 to 1/11/2018. Actually, petitioners is removed.
Lordship had asked for instruction why this was not paid. This instruction has come and this order, the SP has actually passed an order saying that everything else will be regularized, but the pay for that period will not be given.
Why?
Lordship, the source of the power, I think, can be traced back to the FRSR 54B, Your Lordship, but otherwise the order is there, Your Lordship.
FRSR 54B is a case of suspension.
No.
No, it is
when it is set aside, Your Lordship,
Okay,
by the
yes,
court.
yes. Parawise comment with reference at the honor to submit the Jotin Deka with regard to the student, the petitioner had submitted written application to the APS reinstated with immediate was mentioned in the period from the date show me your order of reinstatement. Show me your order of reinstatement. Where is the order of reinstatement?
One small other thing is that SP has not been made a party order. It's the main.
Don't worry, we'll make it. Where is the order of reinstatement? Madam, you were reinstated?
Already, already joined in this on this.
So there is no inquiry.
No de novo inquiry. I have inquired that also. As
Now,
of now,
if there is no de novo inquiry,
Yeah.
what is this order of 16/5/2022? Had submitted a written application to the undersigned on ER for claiming the area salary. However, the petition could not be entertained as from the record it is found that he was reinstated in service with immediate effect on so and so. Now tell me, reinstated in service, but how are you going to take away his salary for that period? Under what provision?
so that is what I was saying. 54A, not 54B. But
Yes, what does it say?
may I read?
Yes, please.
54A 2.
54.
54A.
A.
I read one also.
54A 1.
Yes, 54A1. Whether dismissal, removal, or compulsory retirement of a government servant is set aside by the court of law and such government servant is reinstated without holding any further inquiry, the period of absence from duty shall be regularized and the government servant shall be paid pay and allowances in accordance with the provisions of sub-rules 2 or 3 subject to the directions, if any, of the court. 2.1. When the dismissal, removal, or compulsory retirement of a government servant is set aside by the court solely on the ground of non-compliance with the requirements of clause 2 of Article 311 of the Constitution, and where he is not exonerated on merits, the government servant shall, subject to the provisions of sub-rule 7 of Rule 54, be paid such proportion of the full pay and allowances to which he would have been entitled had he not been dismissed, removed, or compulsory retired or suspended prior to such dismissal, removal, or compulsory retirement, as the case may be, as the competent authority may determine after giving notice to the government servant of the quantum proposed and after considering the representation, if any, submitted by him in that connection within such period as may be specified in the notice, which in no case shall exceed 60 days from the date on which the notice has been served. This notice, I don't think, Your Lordship, it is apparent from here that any notice has been given, Your Lordship.
Then,
provided that any payment under this sub-rule to a government servant other than a government servant who is governed by the provisions of the Payment of Wages Act 1936 shall be restricted to a period of 3 years immediately preceding the date on which the judgment of the court was passed or the date of retirement or superannuation of such government servant, as the case may be, Your Lord. Should I keep on reading, Your Lord?
Now, tell me, you are saying that you won't pay, but can this amount be less than the subsistence allowance in view of 54(7)? How are you saying that he is not entitled to anything? Wouldn't that be exercising a power without an inquiry in respect under Rule 7 by AB, I think we are C? You are deducting some amount from him. 7 Roman 3. Now, can you do that without an inquiry?
That is what your notice and some kind of a representation notice has to be there, Your Lordship.
No, whatever may be. Can you totally debar? Because Rule 54A 2 also does not say that no amount has to be
Zero
paid.
amount is, it does not contemplate zero amount, Your Lordship.
Yeah.
It says that
Then-
part of the amount will be cut and
No,
that
what
even there,
your instruction which we are getting it out here says reference to the judgment dated so and so is reinstated in service with immediate effect. He shall not be entitled for salary from the date of his discharge until the date of his reinstatement for a period of so and so. How do you exercise this power? Is it possible to do so in this manner? This is absolutely in violation to the FRSR.
he should have at least given a notice, Your Lordship.
No. Notice also. Tomorrow, if this is allowed, a person 10 years, 12 years, a person will be just, the state of affairs out here. A person is being, first the departmental proceedings takes a long time. After the departmental proceedings is disposed of, appeal is filed, appeal is disposed of, then the matter comes and files a writ petition out here. It takes another 10 years for disposal. Like that in that case. day before yesterday I disposed of. So it takes a long time. Now all this why the petitioner is asking for a particular thing. It is not for his blame that you have not taken anything, you have not initiated. Yes, presenting officer has not been appointed out there, and as such, the inquiry officer becomes the presenting officer and all these things. You are to put him to notice to that effect. That has also not been done. But whatever may, how can you show that you nothing and that too, you are to issue notice within 60 days and decide that aspect? You have not done that. So you are penalizing him without an inquiry under 9(1).
No. That inquiry was set aside.
Understood. So there is no inquiry.
Your lordship.
So are you not penalizing him under 7(3) without an inquiry under 9(1)?
It was supposed to be even here it was written as de novo inquiry should have been done, your lordship. But then subsequently I asked the person that whether de novo inquiry has actually happened. So he said that no. So from 18 to now, no inquiry has gone on.
So he'll be entitled to. Yeah, good. So what to do?
What he will be entitled to, he will be entitled. His entitlement is there, your lord.
Huh?
Yes, your lordship is.
His entitlement is there. Whatever maybe you can't decide. Yeah.
Only thing, your lordship, SP, the person who has signed, not been made a party, your lordship. SP, not been made a party till late. Why it has not been made a party?
Who was supposed to do it?
He is the one who has done it, your lordship. He has passed the order. It's the order of SP Dorong.
Who has passed that order?
The one which is in your hand, your lordship, that is DO number 3628.
Hello. But who is your appointing authority?
I think, your lordship, if she corrects this thing, that if the Dorong SP is brought into as a party, then all the relief which your lordship is contemplating can be given you. That your lordship can do today also if your lordship is of the mind, making him a party.
But if I make him a party,
then your lordship will have to give some time to respond also.
Because response is required. Madam, you do one thing. I make the SP a party. Madam, kindly listen. I make the SP a party. You hold to this.
I'll give her.
Bring it by way of an additional affidavit and say that this has not been done in terms with FR 54A. Okay. Then you give me the lever so that I can put the oil and gas and then to proceed and give you the relief. Okay. Can you do that?
Only one party, otherwise.
I hope, madam, you are understanding what I am saying.
Yes, actually, the order is passed by the Deputy Inspector General of Police. Order passed by Deputy Inspector General of Police. And actually, I want to rely upon one judgment, lordship. Read appeal number 211 of 2019 and passed by the Honorable Court Dipali Bormon. The same similar matters, lordship.
No, madam, you are understanding. What has happened, the instructions which have come is that there is an order by the Superintendent of Police on 21/11/2018,
yes,
while reinstating you,
yes,
has categorically mentioned that you won't be entitled to the salary during that period.
yes.
Are you aware of that order or not?
During that, actually, is that due to the fault of this authority, so I cannot able to do this service.
So, madam, are you aware of this order or not? Were you reinstated or not?
Reinstated
And, on what basis?
because the renewal period is remove service is already passed.
How were you reinstated?
Order to what?
No, reinstated orders have not there.
But you must have definitely received it because otherwise you wouldn't have been working.
Actually, at that time, I have no knowledge.
When did you file the writ petition? You filed the writ petition in 2023. How are you saying that you had no knowledge?
After comply this order was reinstated service on 21/11/2018.
Absolutely.
Yes.
Now, do you have that order?
No, I don't have any order.
Let me give that order.
Now, this order, you need to challenge it. Challenge it by way of an affidavit. Give it to him. Isn't it? By way of an additional affidavit, you challenge this order. And on the basis thereof, I will pass an order in your favor. But without a challenge to this order, it becomes difficult. I have to say this order is wrong. How do I say? Heard, Miss?
Yes, Chakraborty.
S. Chakraborty, the learned counsel appearing on behalf of the petitioner. Mr. C.S. Hazarika appears on behalf of the respondent numbers 1, 2, and 3. During the course of the hearing, the learned counsel appearing on behalf of the respondent number 1, 2, and 3 had submitted that the petitioner have not been paid the arrears salary for the period from 11/12/2014 to 20/11/2018. In view of the order dated 21/11/2018 issued by the Superintendent of Police Dorong Mongoldoy, whereby though the petitioner was reinstated from service, reinstated into the service with immediate effect, that is from 20/11/2018. But it has been held that the petitioner would not be entitled for salary from the date of his discharge until the date of his reinstatement. The learned counsel appearing on behalf of the petitioner submits that as the order dated 21/11/2018 is an impediment for the purpose of the salary of the petitioner, the petitioner, the Superintendent of Police Dorong Mongoldoy, is required to be made a party. And further, there is a requirement of challenge to the said order dated 21/11/2018 only to the limited extent of depriving the petitioner of his salary from the date of his discharge till the date of his reinstatement. Yes, you have retired.
No, he was in service.
Huh?
His service.
You're not retired.
No.
Oh. You are what? You are a police officer.
Yes. This is actually posted ABC 31 June.
Taking into account the same, this court grants the liberty to the petitioner to file appropriate applications for bringing in on record the superintendent of police, Dorong Moldoy, as well as also to challenge the order dated 21/11/2018 as permissible under law. Release the matter again on 12th of June 2023. Madam, you have to file a separate writ petition. Challenge this only to that extent, nothing more than that. And you return it to him this thing. Because I recorded quite it. Because without a challenge, it would be difficult.
44.
Yes, Mr. Saikia.
By your lordship order on 26/4/2023, the respondents were directed to submit the status of the committee that was constituted to find the effective date of the payroll.
Oh, that representation, Mr. Kotoki. There was some representation to be submitted, na? As regards
committee report.
committee report. The learned counsel on behalf of the respondent are directed to apprise this court on the next returnable date as what is the status of the recommendations sought for the applicability of the ROP 2017 by the committee constituted and whether the exact effective date have been given in the recommendation. Anything?
Committee they took a decision on 10/5/23.
So this writ petition has been added fuel to the committee.
Right.
After discussing the issue regarding the feasibility of giving effect of the RP from 1/1/2000 and having regard to the financial intermediary. This is because the same will change without it. Yes, goes against you.
Let us file an affidavit. File an
File an affidavit. That day, that judgment, na, Amar Goel or what is that, Mr. Kotoki? That matter, I passed that order, na, long time. On is her data.
One is PM Sampat.
And the other is
Amarnath Goel.
Yeah. Amarnath Goel, paragraph 28 will do you wonders for this matter. Mr. P.J. Saikia, the learned senior counsel, assisted by Mr. M. Nirola, learned counsel for the petitioner. The S. Kotoki appears on behalf of the respondent number 3 to 6. And madam, you are appearing for?
Respondent number 2 and 5.
Your name?
Arte.
And so appears for the respondent number, Ardeka appears for respondent number 2 and 5. None appears on behalf of the respondent number 1, 4, and 7 on call. In pursuance to the directions passed by this court on 26/4/2023, the learned counsel appearing on behalf of the respondent number 3 to 6, Mr. S. Kotoki, has submitted that the committee have taken a decision on 10/5/2023 to examine 10/5/2000 as regards the feasibility of giving effect of the ROP from 1/1/2016 and taking into account the financial implications thereof to the tune of rupees 77,59,17,310. It was considered that it would not be feasible to grant the benefit from 1/1/2016. In that regard, the minutes of the meeting, a copy of the minutes of the meeting have been submitted before this court, which is kept on record and marked with the letter X. Taking into account the same, the respondent, the petitioner. Yes, what do you want to say? Why should he file an affidavit? He has said it is not feasible.
Well, that is the third prayer of merit. But there are other two other prayers. We want for a direction for implementation of the pay commission as in total
From
1/1/2016.
He says this is not possible, but the others is
That's a committee that was constituted.
no. So the committee has decided
Otherwise,
that.
otherwise pay commission, my lord, they have recommended for giving effect from 1/1/2016.
No, that's the pay commission recommend on behalf of these companies also. Show me how is it possible? Because if I know it properly, it is on the basis of these rules. It says that there has to be a specific order from the government extending that particular ROP. That's the mandate of the rules.
The pay committee has recommended, that has been accepted by the board of the companies, and while giving effect, the pay commission has recommended with effect from 1/1/2016
For whom?
for all the employees of the three companies.
Where is that? Show me that document.
This board meeting, my lord, is at page 122.
1/1/22. Yes. The board considered the recommendation of the pay committee and the suggestions made by the scrutiny in respect to so being the nominee of the final find that whereas the Assam service has come into effect from 1/4/2016. It would be prudent if the result also comes into effect from 1 in place of 1/1 as recommended by the pay committee in the line of the government. He also stated that the revision may be effected in such a way that the so are not required to approach the government for financial assistance for payment. The board therefore agreed to follow the ROP in line with the schedule giving effect with effect from 1/4/2016 on an interim basis. A committee of 3 MDs would further examine the implication of giving effect from Iman as recommended by so. So the decision was from 1/4/2016 as per what has been given by the government.
That is of the government.
Yes, no, that is what, for that they are going, they as an interim, they gave it from 1/4/2016. And a committee was to decide as to whether they are going to do from 1/1/2016 or not. Now the committee has come up and decided this, that they are going to do, it is not possible because the amount to be paid is 77 crores. Then
all these aspects have been considered by the pay committee. How to augment the revenue, what is the implication. Otherwise, all this, the entire recommendation of the pay committee has been accepted by them, except giving effect to the date of implementation. And they have taken the analogy of the that the state government has implemented it with effect from 1/4/2016. But that is
no. Are they not in a position to say, look here, we are not going to give you from this, I will give you from that? Isn't it absolutely within their financial or within their jurisdiction to do so? And how can this court under 226 interfere with that aspect?
Because the pay committee that has considered all these aspects of the matter, they have given various measures how to augment the revenue and what would be the implication, etc. This has been given. So now what has been stated, something about 77 crores, the total implication. Now here the as per the recommendation of the pay committee, this can easily be overcome.
How?
Whether those that aspect has been considered by the this committee or not. That will be there, and this
No,
again has to be
the
accepted.
committee in its financial wisdom have decided that this will entail a further expenditure of 77 crores. So they don't want to do it. How can this court enter into their financial wisdom, Mr. Sakia? It will have a far-reaching consequences the once this court enters into all those aspects of the matter. More so in view of paragraph number 28 of Amarnath Goyal.
Amarnath Goyal.
They're difficult. They're absolutely within their jurisdiction or domain to decide that aspect of the matter. How can this court decide anything on that? Yes. You take a call. I've recorded this.
Yes.
It's kept on that. Mr. Kotoke, you give a copy of this. During the course of the hearing, Mr. Kotoke appearing on behalf of the respondent number 1, 2, and 3, 3, 4, and 5, and 3 to 6 have also served a copy of the minutes to the petition, learned counsel for the petition. List the matter again on 28th of June 2022. 52.
Instruction was sought for regarding the status of the pensionary benefit.
Yes, what is the status?
Here, my lord, on 6/5/2023, the Director of Secondary Education has received the area salary proposal from the Inspector of School. And regarding pension, my lord, I need some more time, my lord.
Area salary?
Yeah.
And pension?
Pension, I need some more time, my lord.
Hello. Heard Mr. R. Islam, the learned counsel, appearing on behalf of the petitioner. Since how long you have not got anything?
My lord, he retired on 31/12/2021, and area salary.
Have you got it? Are you getting provisional?
No, nothing.
Oh,
nothing.
What is this?
Actually, he was under suspicion. Subsequently, suspension period was regularized. So now the Inspector of School submitted the area salary proposal.
Understood. Whatever may be, is he not entitled to
Provisional, yes, my lord.
Then provisional?
Yes.
Why you are not paying him? On one hand, you are thinking of doing it, but he has not got his provisional. Do pay the provisional.
Yes, my lord. My lord.
No, it is not the fact that he is not entitled to pension. Is it the fact?
No, my lord.
He is entitled to the pension. So obviously, then pay his provisional.
Yes,
We'll see there. Mr. R. Islam, the learned counsel for the petitioner, Mr. N.J. Khatunia appears on behalf of the Secondary Education Department, and Mr. S.R. Burwa appears on behalf of the Director of Pension, and M. Mali, so and so appears on behalf of the respondent number 4. The learned counsel appearing on behalf of the Secondary Education Department, Mr. N.J. Khatunia, submits that the area salary proposal have been received by the Director of
Secondary Education.
Secondary Education, Elementary Education, not Secondary Education. Submits that the area salary the proposal of the petitioner have been received by the Director of Secondary Education on 6/5/2023. However, for the purpose as regards the proposal for pension, he requires some more time to get the instructions. Be that as it may, Mr. R. Islam, the learned counsel appearing on behalf of the petitioner, submits that the petitioner retired on 31/12/2021, and till date, the petitioner have not received any provisional pension. Referring to Rule 22 of the Assam Service Pension Rules 1969, as well as the Office Memorandum dated 21/6/2012, the learned counsel for the petitioner submits that the petitioner is entitled to the provisional pension immediately upon his retirement. He further submitted that the petitioner is in dire straits in view of non-receipt of any provisional pension. taking into account the provisions of Rule 22 of the Assam Service Bracket Pension Rules 1969, as well as the Office Memorandum dated 21/6/2012. And further to the fact, and further upon inquiring, and further, there being no doubt, there is no dispute that the petitioner is entitled to pension. This court therefore directs the Secondary Education Department to pay the provisional pension to the petitioner forthwith. Full stop. No, as early as possible, and preferably within 30 days from the date of the instant order. A certified copy of the instant order is served upon the Director of Secondary Education. Full stop. The Learning Council, appearing on behalf of the Secondary Education Department, as well as the Director of Pension, shall apprise this court on the next returnable date as to what is the status of the pension proposal of the petitioner, as well as also the status of the area salary of the petitioner. This is the matter again on Ekon Gurao. I'm like
The subsistence allowance is subsistence allowance also not.
first let us get your provisional, then we'll speak.
Yes. In fact, in area salary proposal, that proposal also there, madam.
July নিদিব না না মে কোন কত জুনটো লগাওক জুনত আহিলে জুলাই আহি যাব না মেৰ পিছতে জুন কোন লগাওক এইটো লগাওক গুড This is the matter again on 19th of July 2023.
19th of June, right?
July.
July.
In the meantime, I hope we get something.
Yes.
I have given 30 days for the purpose of payment of the subsistence allowance, what you call the provisional pension.
58.
By the order dated 3/4/2023, I was allowed to take service of notice upon respondent number 4 by way of the state. And that
I didn't know, Mr. Sharma, somebody was appearing. Your voice, tell me.
the Lordship, I was allowed to take the service of notice upon respondent number 4 by way
What is
of
your matter about?
relates transfer of the petitioner, Lordship, and my contention-
Entitling to transfer shall not be entitled to transfer traveling and allowance as it is transferred in his own. What is your case?
Lordship, it was my case that only to accommodate the respondent number 4, my transfer was being effected.
Okay, so you have challenged the transfer order.
Yes, sir.
Did you get a stay?
Yes, Lord.
Huh?
Yes, Lord.
Lucky man.
The transfer order is at page 25. Lordship.
You transfer order is of 28/3/2023, isn't it?
That is the modification order, yes. That is the impugned order.
28/3/2023. Why? Transfer order issued by the Director of Economics and Statistics, Assam, on 18/3, then partial modification order. Now you are agree with
Lordship 25, page 25, annex 6.
25. Hello. Yes.
The earlier
Your
one-
name is what?
My name is
Pushpa Datta. Pushpa Datta. Yes. Present place of posting subdivisional of the Dhemaji to subdivision 1 to Majuli. You don't like Majuli. Earlier you were from
I was at
present to Majuli. No, 18th was what?
Lordship,
The same order, Lordship. The
Yes.
same order, the modification is, your Lordship will get it at down below at page annexure 6, page 25, NB. As your Lordship got
Deepmali
it.
Junior Assistant will proceed first and join his new place of posting.
Sri Millie, junior assistant not be entitled for the transfer TA due to own interest of his transfer. Because of this lordship, this honorable court has interfered.
Yeah.
The same transfer order, the 18th, that was that modification that she is not entitled for the TA.
How many years you are there?
Lordship, I was there for
2014.
Then what case do you have? Is your post transferable?
No, Lord. In terms of the ministerial rules, that
Why don't you get is your appointment out there mentioned that MP Sharma will be appointed out here as subdivisional statistical officer subject to promotion at Dhemaji only? Is it mentioned? So show me that appointment order. You are there from 2014. How long can a person stay? After some time you are coming. The last only 1 or 2 years are left for superannuation. Therefore, don't transfer me anywhere.
no, Lordship, that was not the case. What was projected was that, Lordship. In terms of
Your basic case is that look here. Earlier in 18th March there was no mention. Now I have come to learn that now in view of this, this person is not has been placed in my place, and as it is at his own interest. So you are saying that this is being done.
yes, sir. But in the previous portion, it's been mentioned as
No. First and foremost, tell me. Understood. If it is within this period of 2 years, if something to that effect has happened, I would have understood. But if it is an incidence of service, are you saying that they can't be transferred?
in terms of the ministerial rules, Lordship, that's not being done generally.
The same thing happens to the petitioner also. If your lordships come to page annexure 4, page 23, in 2014, Sri Puspa Datta, number 1, at your own request, the following junior assistants are hereby transferred and placed as shown below against their names with immediate effect. And until further, they are not entitled to TA. Then number 1 is the petitioner lord.
That was a mutual transfer.
So this was again interest.
Lordship.
Now you don't like to go to Majuli. Then now show me. Means can the people be transferred as per these rules of 1967? It's not transferable.
Transferable, Lord.
But it was sought to be made with the interest of
You like this particular Dhemaji, not
to
Majuli?
be made in the interest of public, Lordship, but that
Oh.
was not the case.
Tell me, if a normal course of transfer can be made or not, whether in public service or not, public interest or not.
Can be made, but Lordship,
Why do you need a public interest for that? I would have understood. If in the meantime, within these 2 years, if the transfer is being made, it has to be in public interest because of the office memorandums protecting it.
Lordship, on the earlier occasion,
The judge
they
was
were
very kind
required
enough.
they were required to obtain instruction with regard to whether it was at the behest of the respondent number 4 that my transfer was being.
So what? Let us assume that at his behest it was done. So
Then it is not in the interest of public, Lordship. The order becomes.
no, is it mentioned in the interest of prompt and smooth functioning? That is mentioned, no public interest.
Lordship will kindly turn to page 25, Lordship.
Yes.
The initial portion, Lord. In partial modification of the office order that is so and so, in the interest of public services, the following junior assistants of the so and so officers under this directorate are hereby transferred and posted so and so, Lordship. It is in the interest of public, that is we mentioned in this order.
So,
Lordship, what?
Okay, we can do one thing. We can keep the Dhemaji post blank. You go to Majuli. Let him stay at Dibrugarh. So he is there.
I was serving there in Dhemaji, Lord.
No, here Jatin Datta has got
But that
to,
was not disturbed, Lordship.
now because of you, huh?
That order
Jatin Datta is supposed to go to Dibrugarh.
Lordship.
Deepmal Mili is supposed to go to Dhemaji, and you are supposed to go to Madhuli.
Yes, Lordship.
So all between all three of you, this transfer is happening.
The order dated 18/3/2023 was not implemented at all, Lordship, and I was there in Dhemaji itself. So that
How
was,
can it be implemented? Because this person was asking for something.
subsequently it was modified.
No, Mr. Sharma. No case. Answer, this court shouldn't touch it.
But on the face of it,
You allege malafide against the director of economics, then we do it. You want to allege it. Or allege that it has been done in the manner of a vindictive nature, we'll do it.
only with
Otherwise,
public interest. There is no public interest in this transfer or spend that. So I paid that.
where is it mentioned that it is in public interest?
Here it is mentioned, Lordship.
Public service.
Public service.
Public service and public interest are different.
Public service.
Interestingly, you won't find the term public service anywhere mentioned in the interest of public service. Is the public interest you'll find many places. You don't have a
Same
case.
thing, Lordship.
What do you say?
Lordship,
Only
otherwise-
because of one line you have added, this has
Yes, Lordship,
destroyed your
because of
case.
that. Because of that,
What
had
is
we
your
had,
instructions on that? On the last occasion, you were asked to take instruction. What has
Lordship,
happened?
that instruction we have received that pursuant to the direction of this honorable court, that that transfer order is stayed, suspended, Lord.
Which
That
one?
is the transfer order pursuant to the direction of this honorable court.
Obviously, that I know, but why did you do it?
Yes, Lordship. That part yet to get, Lordship.
Why?
What inspired them to issue this modification order,
No,
Lord?
Mr. Sharma, you should thank the other Sharma.
Lordship, can be posted after 2-3 days, Lordship. Maybe to respect to
2-3 days also, this court is not changing its view. The view is same. Transfer matter is, I remember till now, I've been sitting from the month of February onwards, till now, there is only 3 transfer orders I've given stay. And you were lucky enough, this matter went in somewhere and got this thing.
Any adverse order is passed, let it be passed on presence of my senior.
Who is your senior?
You can add.
Senior, no senior, hardly would make a difference. Anyways, you get your chance because this Sharma is giving you the chance to that. Get your instructions. Or should you make it absolute? The state will issue rule.
Lordship, let us get an instruction that
Let
what
us issue
inspired
rule.
him.
Issue rule and keep it. Let us come after 10 years.
It's not that much only I have to submit.
What submission is there?
That Lordship.
Save it for 2 days.
So, Lordship, let him obey the instruction.
His instruction is heard Mr. MP Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. H. Sharma appears on behalf of the respondent numbers 1, 2, and 3.
1, 2, and 3, Lord.
This court, on the last occasion, had directed the government, the council appearing on behalf of the respondent number 1, 2, and 3 to obtain instructions as to the reasons why the impugned order dated 28/3/2023 was passed. However, Mr. Sharma seeks for an H. Sharma seeks for an accommodation. Accordingly, let the matter be listed again. When? July?
Which like what?
August?
Lordship, in the last part of June.
Seeks for an accommodation. Taking into account that this is a matter of transfer, that the matter be listed on, there is what?
This is May. Lordship, last part of May.
Shall obtain the instruction by 19th of May without fail. Interim order passed earlier shall continue till then. Yes, any urgent matter? No urgent matter. Mr. Sharma, Mr. Das, you always come up with an urgent matter.
65, my lord, 65 I have got appointed and my husband expired 83. I am not receiving anything, my lord. Pension. I have the urgency, my lord. That's why, my lord, 24 it is left over several days.
Okay, give a date.
Yes, my lord. Item 20.
Yes, Mr. Bhagavati.
Item number 47.
What is that? It is not there in the list also.
Let it come on another day, Lordship. So that area, given Lordship, person has retained.
Item 11, pension matter.
Tell me which is not a pension matter, right, left, and center. All matters are pension matters. Anyway.
May I please?
32 may be given a date.
32?
Yes.
We'll have it. You can take your dates from me.
এইবিলাক লেট হ'ব লাগিব